36 and 37, Lordship. I want to withdraw with liberty, Lordship, which ought to have been RSA, Lordship, because not under urban area rent control, but under the PPA, Lordship. That's why. Similar other one has been, Lordship. Your Lordship has, this court has allowed me to withdraw with liberty to file,
Mr.
Lordship.
Chakraborty, we'll do one thing. We'll take it up at 2.
Two.
2. I'll just pass the order because I have to say, I have to give you the limitation. Okay? Because without the limitation, you will be in trouble. And also an order to that effect that you will be entitled to get the certified copy.
And the I want the certified copy also back.
So those orders have to be passed.
Lordship.
Take it up at
Please, Lordship, I beg to mention item number 35. Lordship, can I adjourn the matter for the day? My senior is out of state. I am for the respondent, my lord.
Why the IAs have come?
For vacating, my lord, stay vacating.
At the request of the Learned Counsel for the applicant.
No, my lord, I am the applicant in the IA. In this case, is the
At the request of the respondent, counsel appearing on behalf of the appellant. In this case, is appellant.
my lord.
Matter stands adjourned to be listed after 4 weeks.
My lord, date may be. Stay vacating.
Stop me.
If you mentioned the early hearing application note earlier, I had noted, but
Just come today.
no, it is not come. I'm praying for listing of that. It is not coming.
Earlier.
Any date.
We'll have it on 27th.
March. Sure. Keep it.
I beg to submit a bench on name.
Hmm?
I beg to submit a bench on name for list of the case on 4-4. 4-4.
You
Yeah.
want a matter to be listed.
Yeah.
What is the matter?
TRP.
CRP.
TRP. TRP.
TRP. When?
On 4-4.
Not 4-4. 5-4. But 4-4. Transfer petition.
Right.
Transfer petitions are not eligible on Tuesdays and Thursdays. 5-4.
Is the Lordship. I'd like to mention 2 RSA for listing. That was last posted on 20 of this month, but it was left over.
Hearing.
Yes, sir. What? It's the matter related to what hearing.
41. Order 41, rule 11. Okay. Have it. You are respondent most probably.
Yes, sir.
5th of April.
May please, your lordship. As instructed by ONGC, I may be allowed to withdraw this petition. The matter has been resolved between the parties already.
The learned counsel appearing on behalf of the appellant. Mr.
T. Das.
Adas
T. Das. T.
T. Das.
Das.
Submits that he may be permitted to withdraw the instant application in view of the fact that the matter has been amicably resolved. Mr.
R. Swami. I'm for the
appears
respondent.
on behalf of the respondent and does not oppose the same.
Yes.
Accordingly, the instant appeal stands dismissed on withdrawal. IA's intelligent records have come. Please shall return the records to the courts below. Any interim orders for past that
Obliged.
Alright.
Yes, what is this?
That is your Lordship. This matter pertains to a revision wherein we have challenged the Supreme order passed by the learned civil judge in the revision and property.
Rejection of plaint.
Yes, ma'am. Filed a petition on the Order 7 Rule 11. for
Your
the-
plaint has been rejected.
No, my lord, we prefer the petition. We being the defendant, we prefer the petition for rejecting the plaint of the plaintiff. That is the,
Why?
because my lord, they failed to disclose the good cause of action. And moreover, the suit is barred under Section 3 of the Limitation Act.
Truth is
So far as-
barred.
Yes,
Why?
because my lord, if lordship, I would like to state the facts of the case. The
Hmm.
first instance,
Where is the plaint?
plaint, my lord,
I won't go into the facts. I'll see the plaint. Where is the plaint?
my lord, at page number 22, my lord, that is annexure number 1. This is the copy of the plaint, my lord. On page 24, my lord.
Put for declaration of right, title, and interest in favor of the plaintiff. For the- That's it. You are asking why it is barred?
But, my lord,
Limitation.
on limitation as well as it failed to disclose a good cause of action.
140 Order 7 Rule 11. Why?
Because, my lord, it failed to disclose a good cause of action as well as it is barred. Because, my lord, it is their own admission on the
Hmm.
part of the plaintiff. If, my lord, it comes to to the in their pleadings, manner, that is not paragraph number 1. Manner. For so far as they have stated that during the period of settlement operation, my lord, of the year of 1958 and 59, land measuring 7, that is the suit land, my lord, was under an annual pata. And the said land was originally settled by the government of Assam with the two original patadars, namely Sri Roheswari Patak and Sri Bhabandanath Patak. And accordingly, they were in joint possession thereof by paying the land revenue regularly. But subsequently, the said suit land was covered by annual tax number 33, was converted into periodic land by creating a new KP Patta number 58 of village so and so by order of the Learned Circle Office Orthabari dated 5/2/96 in connection with the periodic petition number 701 of 95 and 90. Is their own admission.
Then
So, my lord, they have admitted at the same time when there was a subsisting annual pata, the said land was settled in the name of the original patatar, being the predecessor of the said petitioner. Thereafter,
who are the plaintiffs?
plaintiff, my lord, plaintiff here they have, so far as the claim, the plaintiff are the respondent number 1 to 5. Their claim was that they purchased the said suit land while the period of subsisting annual pata by unregistered agreement for sale. So far as my lord, unregistered agreement for sale is concerned, my lord, it does not confer any title,
Unregistered
deed of sale.
deed of sale.
Yes,
They purchased it on the basis of unregistered
The
deed of
deed of
sale
sale.
from
in the year of 1981 and 1984
from
from the predecessors of the petition, my lord, there being the father,
okay.
being the
Then
parents. So, my lord, they purchased way back in 1981 and 1980. They had admitted the sale. So, my lord, we were in possession, my. If they had been in possession, my lord, that it would have been settled in their name. Now, on connection with the periodic petition, my lord, on in the year of 96, pata was being conferred to us, my lord. Similarly, we held possession all these years, and they created a cause of action being illusory in nature. My lord. Just a clear case of clever term.
So, what do you say about disturbing the peaceful possession?
My lord, so far as our possession is concerned, so far as the suit land, my lord, in that suit land, there is a pond. There happens to be a pond covering the whole area. And my lord, without, since it was under our possession, my lord, they have started to disturb us. While a demarcation proceeding
No,
has
no,
been
no, no.
instituted, my lord,
Mr. Thakur, Mr. When we are deciding an Order 7 Rule 11 application, we are to think that the plaintiff says whatever is like a gospel truth. Okay? Out there, they say that they have been possessing the land from 1981. Maybe. They don't have a right. They don't have a declaration of their right. They may not get because it's an unregistered document. They may not. But the fact that they are in possession, which they claim to be, can the suit be rejected?
because so far as this entire application which they have proposed, they have instituted before the learned prayer. It is nothing but the abuse of the process of because, my lord, we held possession. If they were to sought any relief,
How
before
can I take into account, or the court can take into account, that you are in possession when they say that they are in possession? Isn't it a question of trial?
but so for our case, we have already filed our written statement, but as the apex court has been quite clear in this respect that, my lord, only the plain what they have
Mr.
projected.
Counsel, have you ever read the judgment on Liverpool of the Supreme Court? More particularly paragraph number 151 and 152. Supreme Court say that a suit may be a plaintiff, if it is drafted, he may not, at the end of the trial, he may not get a relief. But that is not a ground for striking out. Because for striking out, one has to go into the question of the, it has to fall within the parameters. One is not disclose the cause of action. Here he says from 1981, after the purchase, he has been in continuous possession of the suit land. And on 22/2023, you started disturbing him. And when you started disturbing him, therefore, he is asking for right title interest or whatever may be, along with also a permanent injunction to the effect that not to disturb him. So under such circumstances, whether at the end of the trial you are able to show that actually you are in possession, he is not in possession, is a question of fact. And where is the question of bar? He says that on 22/2023, he has disturbed you. You are disturbing him. What is the limitation for permanent injunction?
The careful on the careful perusal of the plain,
Hmm?
we go if the averments made in the plain, we go was there on contradictory stand.
Now the next question arises, are you going to withdraw or should I dismiss on the motion itself? Notice to this court is not doing. Either. Which one? I think better withdraw. What do you want? Tell me. Fast.
My lord, we take instruction from my
No, no, no. Instruction is when you stand in the court. Instruction is not there. Now, okay, then I dismiss it.
no. Mr. But my lord,
No, no, the order is right.
I tried to project the case because since
No.
the trial court, since they passed the order, my lord, here in the order, my lord, the opinion so far it was drawn by a trial court for dismissing our petition. My lord comes to the order. Okay. That is on
Order absolutely rightly passed.
page 158.
Chalo.
And so
I
far as
dismiss it. Heard Mr. So-and-so, the learned
my lord,
counsel.
maybe we are allowed to withdraw.
Wait. Learned counsel appearing on behalf of the petitioner submits that he would not like to further press the instant petition, for which the instant petition stands dismissed on withdrawal. the instant application under section 115 of the Code of Civil Procedure 1908 is directed against the order dated 4/1/2024 passed in Mijay case number 121/2023 arising out of title suit number 38/2023. The said application was filed seeking rejection of the claim on the ground that the plaintiff does not disclose of cause of action, and further, from a perusal of the plaintiff, the suit appears to be barred by limitation. The learned counsel appearing on behalf of the petitioner submits that these aspects, being questions of facts which will require determination before the learned trial court in the course of the trial, would not like to press the instant petition, for which the instant petition has dismissed from the trial.
We do not want to press this petition. May be allowed to withdraw my vote.
Huh?
We do not want to press this petition because a review petition already been filed on the same matter.
Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the instant petition in view of the fact that a review petition has been filed by the petitioner against the order dated. What is the date of the order?
2/2024, madam.
2/2024. Passed in. Oh, is this the matter?
Yes, yes, that.
I've directed that to what has happened to 8/4.
Yes, 8-4.
I've asked you to file an for appearance for hearing everything.
Yes,
Not like to press the instant matter. Accordingly, the instant petition against the order dated 2/2024 passed in Mijay case number 657/2023 arising out of title suit number 765/2020. Taking into account the above, the instant petition filed under Article 227 of the Constitution is dismissed on withdrawal.
Lies.
Nowadays, it has become the Constitution of Bharat. Huh? Yes, Mr. Additional Advocate General. What do you say? Right out there, Article 227 of the Constitution of Bharat.
Yes, yes.
You write it?
Yes,
Nothing.
I write.
It is changed.
Whether it has been given effect or not, madam, I don't.
But to my knowledge, I don't think it has till date been done.
Madam.
चलो Constitution of India लिखी हुई थी भारत ने लिखी. Yes, item number 4.
Please, Lordship. Lordship, my property is under threat because of the issuance of the injunction order restraining myself from my property. I was the defendant in the original suit, and I am being the title holder. The plaintiff has preferred a suit for claiming the possession ownership title. Ownership
Show me
title.
that. Where is the suit?
Suit is at page.
Hmm?
Lordship, paragraph, page number
Page 19.
19 to 20.
Suit for declaration and of ownership, right by virtue of possession, and also for injunction. What is the relief for?
Here, page number 20.
Declaration of the ownership right of the plaintiff in the suit by virtue of possession. Permanent injunction restraining the defendant from entering into the suit land, but also restraining him from causing any sort of disturbance, annoyance in the peaceful occupation of the plaintiff. Now what happened?
Interim injunction
What did
is
the trial
granted.
court do?
Interim
Trial court's
injunction
order?
is granted.
Huh?
Interim injunction is granted restraining the defendant.
Where,
to
where,
enter
where?
into-
Where's the trial court's order?
Trial court order is page number 42.
Okay, then
Then Lordship,
you filed an appeal.
appeal, it was dismissed. Lordship, I do not say that injunction may not be granted because they are in possession. I am allowing them to occupy the land for cultivating purposes. But as and when they claim their ownership, I filed counterclaim also to evict them. So the land in question is now disputed, is admitted there. And I am in apprehension that since we are restraining the nature and character of the of this land,
Did
maybe
you file an injunction application there?
I am not filed.
Then how do I give you? Tell me.
So
If you are asking for that no nature and character should be there, don't you think that there should be an injunction? When that too, when you have filed a counterclaim, and more particularly as a defendant under Order 39, Rule 2, you are entitled to, don't you think?
Yes, definitely, Lordship.
I give you the liberty to withdraw this thing and giving you the liberty to move an application for that.
Of
I
that.
think better off
Yes,
that
yes,
one, huh?
of course.
This is an application under Article 7 of the Constitution challenging the order dated 21/2024 passed in Miss Appeal number 34/2023, whereby the learned First Appellate Court affirmed the order dated 23/9/2022 passed by the learned Munsif number 2 in Miss case number 73/2022 arising out of title suit number
That is
title suit number
citation number 93 of 2020.
93/2022. This court have duly perused the suit which has been filed. And from the said suit, it reveals that the claim made by the plaintiff, who are the respondents herein, is for declaration of their right, title, and interest on the basis of adverse possession,
I thought so.
as well as also seeking permanent injunction that the plaintiff, that the petitioner herein, who is the defendant in the suit, should not disturb his possession, disturb the possession of the plaintiff. The learned trial court, by the order dated 23/9/2022, in Mize case number 73/2022, had restrained the petitioner herein from disturbing the possession of the respondent, disturbing the possession of the plaintiff over the suit premises in any manner till the disposal of the said suit. The learned counsel appearing on behalf of the petitioner submits that the petitioner have also filed a counterclaim for eviction of the defendant of the plaintiff. He, however, submitted that this court that the petitioner is not insisting for the purpose of changing the status quo, but at status quo as regards possession, but the plaintiff, the petitioner, seeks an order to the effect that during the during the possession of the plaintiff, during the the petitioner is seeking an order to the effect that during the pendency of the suit, the nature and character of the suit land should not be changed. This court is of the opinion that the same aspect, this court is of the opinion that the order which the petitioner herein is asking for has to be based on an injunction application filed by the petitioner before the trial court, and not in the proceedings under Article 2 to 7 of the Constitution challenging the order of granting injunction to the to the plaintiff in favor of the plaintiffs. Consequently, this court further, upon perusal of the impugned order, is not inclined to exercise the jurisdiction under Article 2 to 7 of the Constitution. However, this court grants the liberty to the petitioner, herein who is the defendant in the suit of defendant oblique the counterclaimant in the suit, to file an appropriate application seeking injunction against the plaintiff for not to change the nature and character of the suitland during the pendency of the suit. In such circumstances, such application is filed, the learned trial court shall duly consider the same in accordance with law. Petition. Yes,
My lord, an amendment application was filed to bring for the trial court the subsequent events, my lord. And that my petition was rejected, my lord, by the impugned order dated 21/11/2023. My lord, it is at page,
what is the stage at which you filed?
at the stage, my lord. It is at the hearing it.
Arguments?
No, hearing, evidence.
Well, what
I'm
is
the-
the
I'm
stage
the
of
def-
evidence?
I'm the defendant counterclaimant, my lord.
You are a counterclaimant.
Yes,
What is your stage of the evidence?
Peterbilt, for Peter.
Are you going to, you want the
Amendment. in the
amendment to the written statement or the counterclaim?
counterclaim.
And that was disallowed.
That was, my petition was rejected, my lord.
Why?
My lord is stating in the idea that the learned court has already taken cognizance of the matter and this can be reflected in the judgment.
Huh?
If I can take your lordship page number 66, my lord.
Yes.
Or 65, my lord. Consider 65, second part.
Considering the
Considering the
submissions
submissions made by both the parties and the materials available on record before this court, it appears before me that the proposed amendment sought to be made by the petitioner is based on the subsequent events posterior to the submission of Amin Commissioner's report dated 22/3/2017. It is noteworthy to mention herein that the expression subsequent development which necessitates amendment in the pleading does not necessarily refers to the events as consequent to the judicial decision. The report submitted by the concerned Amin Commissioner on 22/3/2002, it would have been, my lord, 2017, is as per the direction of this court, and the same is on judicial notice of the court. As such, those facts further do not require to be brought on pleading.
Okay, will issue notice. Issue notice, making it returnable. Where, which court?
By the,
Guwahati.
it is now Municipal number 2. Municipal number 2, Guwahati, madam. Civil Judge Unit
No,
Division number 2 at Guwahati.
Making it returnable on 10th of April 2024. Step be taken upon the respondent by way of registered as well as usual. Further to that, the petitioner is also directed to take steps by way of the three routed through the registry of this court and file an affidavit of service
Lord,
on or before the next day.
may I request, my lord, there may be Eid on 10th of April. Ma'am.
Huh?
There may be Eid ul Fitr on 10th of April. So let it be after Bidu.
We'll have it on 5th of April.
Yes, my lord.
On 5th of April.
Oblige.
Because this matter needs to be disposed of as early.
Exactly.
Unnecessary keeping this matter pending. It's only staying. You file it, matter finish.
Today also your lordship can dispose it.
I can't. No,
Let them
if
be-
I do it, other side is not there.
Yes,
On 5th of April. Step be taken Yeah, इतनी करो. This court, the instant application has been filed challenging the order dated
21/11/2023.
21/11/2023 passed in meter case number 80 of the 2019 arising out of title suit number 266 of the 2012. What has happened now? 4 months have gone.
In between, my lord, it is fixed for PW. And the next is my lord on 258.
The said order pertains to an order passed under where order pertains to an order whereby the application filed by the defendant oblique the counterclaimant was rejected. This court had perused the said order, impugned order, and of the prima facie opinion that the grounds on which the application under Order 6 Rule 17 was rejected does not appear to be in consonance with law. Accordingly, this court therefore states the further proceedings of title suit number,
My lord,
title suit number
the TS number, my lord, 266 of the 2012. 266.
number 266 oblique 2012 pending before the court of the civil judge junior division
Junior division number 2.
number 2 Kamrup Metro till the next day.
Obliged.
Yes, Mr. Mazumdar.
So we have made the calculation.
Yes, what is your calculation?
So far as rate of interest is concerned, there is a dispute. We say 6.25% plus 2%. And they have claimed 14.45%.
We are at the stage of execution.
Yes.
And they are asking for how much?
They have asked my government kindly go to the execution.
Hmm?
They have around 4 crore they have asked. Page 23, man. Start from page 19. 23 is the calculation.
How are they asking for 2,850 numbers of log?
That they are not asking. Well, what they are doing is the first mistake they are committing is page 23. Well, serial number 5 and 6. This is they are not entitled to anything from the date of fire to the date of institution of the suit. Because the trial court was very clear that if this interest will be calculated from the date of institution of the suit. In spite of that, they have claimed
No, this 4 crores comes on the basis of that 2850. Maybe because of then. Now, they must have filed it prior to the judgment passed by this court. This execution application was filed.
execution is, that date is not disputed. That is execution petition matter. Yes, it was filed. Date is there. But verification is the first
Where is
page.
their calculation?
Their calculation matter.
Hmm.
Their calculation not will find it page 23.
No, understood. But that calculation is not proper now. How are they taking 2850?
Yes.
Number one,
My
you
lord.
see the main amount comes to because of 166.
Yes.
So that is not there.
But yes, not,
That is not there.
they are
We are
understanding.
concerned with 414 numbers of log.
Yes.
Then divided by so and so, this is something okay, 24.
This is
Claim of the
correct.
staff
Number
quarters
2 is
are
correct.
these
man.
given? Huh?
number two is correct, 444 lakh
Okay.
after modification.
What is the claim for staff quarters? That is
One-
there.
1 lakh fixed.
Total decreted amount comes to this amount,
Yes.
25.
Yes.
Okay. Rate of interest from so and so at 18%.
Ah.
This period they are not entitled
Not
to.
entitled. Very clear.
Interest upon so and so from 22 to 13.3. That is also not entitled to.
No, 5, 6, they are not entitled.
566. Total comes to this 34. Rate of interest as per the bank lending rate is 14.5%. Rate of interest as per this is 16.5. Payment made by the judgment debtor on so and so is 42 lakhs. Total principal is again. There again they come to how do they come to principal plus interest till Iman?
And they have done it in their own way while filing the without having any reference to the good receipt. And it comes to 4 crore 73 lakhs and the entire execution was allowed.
And this was allowed.
Allowed.
Entire thing.
It
Show me that order.
starts from page 134.
30.
134. And the last page operative part is at page 155. Held that thus on the basis of the discussion made above, it is clearly seen that the claim made by the decree holder in the money execution case number 20 as per the schedule of the executive petition is proper and valid.
Yes, Mr. Mishra.
Well, the entire documents are not before your lordship. If your lordship permit me, I will give your lordship the plate. The 18% interest, that amount was included in the total claim made by us for an amount of rupees 2 crores 25 lakhs, 24 lakhs. And thereafter, my lord, when your lordship will kindly turn to page 20, the schedule A and B starts from 22. 22. Schedule A, I'm sorry, it's not very clear, but this is the original that we have. Type copy is there with your lordship. Here we have said cost of so many cubic meter is so much, so 1 crore 56 lakh. And then staff quarter is 1 lakh. Then amount as per schedule A is so and so. Add interest 18% for sum of so and so. So total comes to 2 crores 25 lakh 75,308. Now, if my lord will kindly turn to their application at page 70. Page 70 of CRP. It is the decree starts with from page number 69. The relevant your lordship will get at page 70. The defendant last paragraph, the defendant is liable to pay the plaintiff sum of rupees 2,26,75,388 with interest thereon at the rate of 2% above the bank lending rates as per IRDA. This is, my lord, which is to be calculated as per bank norms as on today, that is 7/3/2013, on the decretal amount per annum, with effect from the date of institution of suit, that is so and so, till final recovery of suit, and also pay a cost of 21,211. So this 18% was included in the amount that has been decreed, and they came before this court. And this court passed an order. There before this court, they did not challenge the interest part. Your Lordship will kindly come to page 72. This is an order passed by this honorable court. Page 72, annexure 4. And I'll take your Lordship to page 117.
And this aspect is also recorded at page 73.
Yeah, well,
Page 73, the appeal, the court, this court duly takes note of what is the decree passed.
Yes.
Page 73, if you see.
page 70.
This appeal has been prepared against
Yes.
the judgment and
My
decree
lord.
dated so-and-so, decreeing
Yes.
the suit by so-and-so for an amount of rupees a month, together with future interest calculated at a rate
Yes.
of 2% per annum
Yes.
above the lending rate of the bank as per the IRDA regulation.
My lord.
Then,
Then, my lord, page 117, if your Lordship will go to paragraph 54 of the decree of the judgment of this honorable court. It is not disputed that as per IRDA regulation, the insured will be entitled to claim interest on the claim amount if settlement is delayed beyond 30 days from the date of submission of the surveyor report. It is also not in dispute that IRDA regulation permits the claim of interest payment by insurance claimant at the rate decreed by the learned trial court. In the memorandum of appeal, although defendants appellants have taken the ground number 13, questioning decision of the trial court as regards issue number 12, this is interest. Issue number 12 is at page 86.
whether the
been-
defendants are liable to pay interest for
Yes.
not settling the demand and for non-payment of year due time. Yes.
Then, yet during hearing of the appeal, no argument has been advanced by the learned counsel for the appellant on the said point.
The ground taken in the memo.
A reading of the ground taken in the memo of appeal also does not indicate with any degree of clarity or precision as to what was the basis of decision of the trial court rendered in issue number 12 is being assailed. On the contrary, what can be seen is that the said ground pertain to decision rendered in issue number 8. As such, I am of the considered opinion that the learned court has rightly decided issue number 10, 12, 15 in favor of the plaintiff by awarding interest rate at the rate of 2% above the bank lending rate as per IRDA regulations with effect from the date of institution of the suit till realization. So they cannot question that 18% thing. It was included in the principal amount after it was decreed. Then,
Now, how do you get the 18%? I mean, I understand it is 2% above the lending rate.
no, that's different. My lord, that question will come only at the time of execution because 2 crore 26 lakhs have already been given to us, which includes 18%. There is no objection. They have filed appeal before this court. They have not even, when the court, my lord, we claimed for 2,800 and something loss. The honorable court, this honorable court allowed 414 out of that. As against that portion of the judgment, we are before the Supreme Court. But they have not challenged that, any other thing. Therefore, Supreme Court, my lord, in SLP has passed an order that nothing will come in the way for executing the amount given by the side. So accordingly, we filed our execution petition and we have, my lord, calculated at the rate for 414 only. If your lordship, the calculation was done because the order says decree, it will be at the as per bank norms. Therefore, we requested the chief manager of Golaghat, who has given lead, who has calculated the interest. And that's what we have claimed. If your lordship, that also is given, my lord, together with
Your
Indeed.
calculation is at page 23.
no, this calculation is that 23 is based on is based on, your lordship will kindly see, there is the index filed along with the execution petition. The next page, my lord, will see. This is to certify that our present mark prime lending unit rate BPRL is 14.45% effective from 4 to 2013.
So it will be 16.45.
That's all. And we have claimed 16.45. And the last page,
No,
4
understood,
is the
but
calculation.
How do you arrive at this 4 crores?
I'll, my lord, we have the last page, if your lordship will see, we have made it simpler as to how the calculation has been made. But page 4, if my lord will see, this is by the chief general manager of the bunch that I have just given to you.
Yes. Retail amount as per the High Court on the date of institution of the
This is 34,000, 34
34
lakhs.
lakhs. How?
Because your lordship will see here, we have made this calculation. Another one, we have given a little history.
No,
also.
I get this point.
My lord,
The
25,
34 lakhs 9,766, it is there at page 23. Kindly come to page 23.
yes, I'll come.
You have arrived at by taking into account the interest from the date of the 22/3/2001 to 13/3/2003. How are you taking that interest?
My lord, that was in my plain, as I have shown.
No, but that was not granted.
That was granted.
Where? That
Your
was not
lordship will see-
granted.
Yes, your lordship will see the decree at page 70. Total amount your lordship will see of the plain, 2 crores 26 lakhs.
No. Here, kindly come to here. 118. With effect from the date of institution of the suit,
is-
that is
My
13.
lord, that is future interest. Because 18, I'm trying to, again, my lord, make myself clear. 8% interest was included in the total amount claimed by us in the plaint itself. In the plaint itself, your lordship will see the plaint. Schedule B. Schedule B.
Yeah.
It will, Schedule B, if your lordship will see. Amount per Schedule A, 1 crore 67 lakh 33,986. Add interest at the rate of 18% on the said sum from 22/3. This is the date of incident, my lord, when the fire took place. To 13/3/2013, 59 lakh 41,000. So this comes to, actually, this is wrong, 226. It is written 225.
No, what happened to the decree when this court passed it?
Yes.
That decree has been modified.
No, modified only to the extent of 414 law.
So you have to therefore take only 414 logs and the
That's how,
interest, and the
that's how
interest
out
was
of,
only given from
no,
the
no,
date
my
of
lord will kindly
institution.
see. 59 lakhs was claimed in the plaint. We reduced it accordingly, proportionally. And if your lordship will
No,
see,
that is not clear from the decree.
my lord,
From neither, you see, the trial court judgment has been modified.
yes,
Now, the first appellate court categorically says that you are only entitled to 414 logs,
my lord,
and the interest will be from the date of institution of the suit till
yes,
that is 13/3/2003.
yes. My
So
lord,
if
will-
that is clear from there, where is the question of and where is the decree?
decree at page 70.
Ordered and no, kindly see the decree.
Decree, my lord.
it is ordered and decreed that the appeal stands partly allowed the plaintiff firm is
Yes.
held entitled to the insurance claim amount covered under exit so and so to the extent of the same relates to 400 a year. The amount payable to the plaintiff under decree would therefore be computed on the basis of so and so. The
Yes.
judgment of theirs stands modified to the above extent. But this also, as regards the interest, only says from 13.3.
That's right. My lord, 220, your lordship will kindly come to 70.
70.
70. Kindly come to 70.
Hmm.
Your
Yeah.
lordship will see it is second paragraph.
Hmm.
It is ordered that the suit is declared in favor of the plaintiff on contest with cause for recovery of 2 crore 26 lakhs.
Hmm.
75,388 only from the defendant, along with future interest. So this is our principal amount at that point of time. Now, your lordship has modified this, modified only to claim to the extent of law. Instead of 2,800, I was asked that you make it 440. Interest that we calculated on 2,000 some was 59 lakhs, as shown in the plate. Here we have reduced it to 8 lakhs proportionately. And your lordship will kindly see the execution order, which is challenged before your lordship. Execution order.
Yes.
At page 151, my lord. The decree holder, your lordship got.
Hmm.
I'll just, my lord, it starts from, I'll place from page 150. 150, last paragraph.
Mr. Mishra, you do one thing. You make this calculation in terms with that 25 lakhs.
It's there.
No. On that amount of 25 or 26 lakhs, whatever it is, you make it
220,
25 lakhs 16,000.
my lord, it is made here, if your lordship will kindly see, at page 152. 152 of the order.
No, not for that period. Don't
Yeah,
calculate
no.
that.
What we have done is,
That will be considered later on, but this amount don't put this 8 lakhs. This 8 lakhs don't put it and then you calculate
yes,
on that.
if on 24/16, on 24/16/305.
Ah.
This is the cost of 414 law.
Hmm.
And then 1 lakh is staff
So
quarter.
on these 25 lakhs, you make this calculation.
Yes, it comes to 8,98,000. It is made just
No, no,
below that.
you have made this for that period.
Yes.
Don't do that. From there, from there, you calculate from 13 feet. You see, for this court now, we'll try to settle it out with this subject to what the further the Supreme Court says out there. I think that is the best way out.
But one it will still remain. So far as the interest is concerned, they have claimed 14.45% on the basis of what they have claimed. But the decree is ambiguous. That is why we filed an application before some court for review of the decree, number one, and also before the executive court, we said, if we go by the IRD norms, it comes to 6.25.
That's what we have charged.
Plus, no, you are not charged. You have charged 14.45%. Page
Plus-
23.
Plus 2.
Plus two we are not disputing. Well, I'll show how we are doing it. Well, I'll just show it to you.
Above bank lending rate as per IRDA calculation.
No, yes. Now, bank lending rate is a rate, my lord, which is declared by the Reserve Bank of India in terms of section 49 of the Reserve Bank of India. I'm just giving you a lot of the English.
So it has to be as on 13/3/2003,
Yes.
not on the date of the
No.
judgment day.
And the IRDA norm says that will be the rate on the basis of which the entire period claim will be determined. Now, 6.25% was the
No,
bank
no,
rate.
show me that. Where is
Well,
it?
No, bank, so far as bank rate is concerned, my lord, we have looked at.
Where is it?
Section, my lord, section
The
49.
bank may make public from time to time the standard rate at which it is prepared to buy or rediscount bills of exchange or other commercial papers for purchase under this act. Where is the lending rate?
My lord, at that time it was we have found out. My lord.
No, where is it? If you don't have it, then we have to believe what he says.
No, my lord.
That is given out
What
there.
they have done is, my lord.
This document of SBI so.
No, my lord, one more aspect is lord.
Benchmark lending rate is 14.55 effective. Bank lending rate as by RIA regulation.
And Lord, you may kindly have a look at this notification of 26th of April 2002. That is Insurance Regulatory and Development Authority notice. This is the IRDA norm.
Where?
Well, I'm applying for.
That has been stated in the High Court judgment, which I have read it out.
It is
2%
there,
above.
it is
They
there.
cannot dispute it, and it's not challenged in the Supreme Court also. They have not gone.
There is no necessity of disputing. It is necessity of seeking a clarification, which we have already sought. And before the executive.
And my lord, they have also filed a review petition for review of the original decree. And last year, we have my lord, we have collected it, review of the order of appellate order, my lord. And your lordship will see this. This was when this was filed. They have filed an IA. They also filed a review.
Page 13 of this document, Dr. You kindly see, this is regulation 9(6).
Your lordship,
Page 13,
On
Hello,
acceptance
second
of
but one paragraph. Upon acceptance of an offer of settlement, as stated in sub-regulation 5 by the insured, The payment of the amount due shall be made within 7 days from the date of acceptance of the offer by the insured. In the cases of delay in the payment, the insurer shall be liable to pay interest at a rate which is 2% above the bank rate prevalent at the beginning of the financial year in which the claim is reviewed by it. That means in that year, whatever was the rate, 2% above that rate for the entire period. And what they have taken, 14.
Not them. You tell me,
Madam.
where is
That is-
it? Where are you saying 6.25? Show me
six-
that. That you don't have it, you are saying that, yeah. So why should we
Madam,
say?
that is on 6.25%. Madam, they have not, they have shown nothing. Just they have claimed 14.5%. And they have claimed on the basis of the latest.
No,
lending rate.
they have a
Madam,
this particular,
Madam,
they claim on the basis of this certificate
Madam,
of 9/3/2013 of the State Bank of India, which was duly taken note of and in the order. Why should we say,
No, madam.
write the order?
No, madam, Dr. Kindly
We
see one.
dismiss your petition. I think you tag along your SLP with the other SLP. What do you say, Mr. Mr.? Better officer? You should take along the SLP to be filed
He has
against
not-
this order
Yes,
with that other.
Yes,
Yes,
this
yes.
I have not challenged. I did not challenge it, pilot. Possibly, I have not been able to convey what I am saying, man. The trial court judgment, which was not modified by the Supreme Court also, so far as its interest part is concerned, trial court judgment is not very clear. It is ambiguous. This is my submission, madam. Lordship may kindly turn to the relevant paragraph.
No, they have given, you see,
Hello.
at the time of execution, the
Hello.
executing court can very well look into that.
Yes.
It has been mentioned that the IRDA rate, you see
IRDA
what
rate,
a
they have not
bank,
taken.
bank lending rate as per the IRDA regulation.
Well, there are two things, madam. This is what I'm trying to convey. Bank lending rate to be very high. IRDA norm is different. IRDA rate is the bank rate, which the Reserve Bank of India charges from the commercial banks for giving loans.
Unless you don't show that, why should we not believe what they are saying?
Madam, we have shown,
You have to show something contrary.
I-
You have not shown it. So
Madam,
why should we?
madam, this they are not disputing. What they are saying is we are claiming 14.4%, they should be given. They are not saying that that was the bank rate at that time.
Yes, they are saying. They
No.
are saying on the basis of this document. Kindly see, this is the document.
Madam, we have seen this. This is bank lending rate. That is why, madam, there is
That
an
is the bank
ambiguity.
lending rate which has been mentioned. You have to therefore show
Madam,
that with the IRDA regulation being brought in,
Madam.
the rate would be different, which you are not
No,
showing it.
No, my lord.
Okay. I think better off we
Madam,
should
6.25%.
dismiss your petition right away.
My lord, 6.25% we are
We
admitting.
are not, I'm not convinced. Let me dismiss. But I think one thing which needs to be done, give us a fresh calculation without taking that 25 lakh, 34 lakhs. Put it on 25 lakhs
But
without prejudice. You just give me a calculation on the basis without prejudice. Just give it. I'm only asking you to make it.
I'll do.
Yeah, just make it and then I modify it and you say,
That-
direct them that in fact this AR should be AR for the time being till it is finally decided.
Then in the calculation, I will write as per your lordship's.
Because that portion out there, because the court make it, the first appellate court said 414 logs and from 13.3.
Yes.
So to bring in something else makes it dicey. It becomes very difficult. So one has to agree to that the first appellate court said this and there is a Supreme Court order to that effect that you can go ahead with execution.
Yes.
So if you put it on that, I will put the calculation on the basis of that and put it out there in my order so that the executing court is much in a better position to take it up with them.
Then, my lord,
And
that means
you have properties out there in Jorhat? Very well. Give your details of the properties tomorrow when the matter is called. Under Order
Madam.
21, Rule 41, give the property that will be put to sale if you are not paying it.
No, we have never said we not pay. We only want a clarification of
The-
what is the exact
The
amount.
clarification I'm giving, unless you show, Mr. Mozumdar, you are just beating around the bush. We are not on that.
No, my lord.
You know, yes, because here he has categorically stated out here that, look here, the bank lending rate is so and so. If you want to show
Right.
that, yes, bank lending rate is different from the IRDA says something else, then are you not required to show it before this court? Or just make it a statement to the effect that, look here, this is different.
Well, I'll show one judgment regarding that.
Judgment won't help you. The only thing which you need to say so before this court is what is the IRDA rate as on
IRDA,
13.3?
Admittedly, IRDA rate and the bank lending rate are different.
I cannot go on that unless you show me. We are not bound.
No, well, this is
I
clarified
am
what
not
is
looking.
IRDA
No,
rate and.
I am not going to look in. I understand.
Madam,
Therefore, you have to show me.
I'll-
What is the IRDA rate? You are not showing it to me.
Lord will give
If you don't show me, then what do I do?
I'll then produce the document, my lord. But admittedly, my lord, they also accept that IRDA rate is.
They are not accepting anything.
They-
They are making it very clear that as on 9/3/2013, the rate was 14.45. They are additionally entitled to 2%, which makes it 16.45. This is their rate which they are
My
calculating.
lord, my lord, that is bank lending. I understand, my lord. That was the bank lending. rate
Mr.
at that time,
Mazumdar,
my lord.
I hope you understand that I have understood what you are trying to convey. But the fact is, I am very sad to say that I am not being able to make you understand
Well, I have
that you are to show before this court that what was the IRDA rate on that date, bank lending rate, which is obviously not there. If you don't show me, then nothing is there. The trial court judgment is right, order is right. I think they should very well proceed.
One
And the
thing,
calculation, what Mr. Mishra has made, it seems to be very rightly done. The only thing I don't like this 34 lakhs, it should be on 25.
My lord, my lord, is subject to what your lordship says. Your lordship is rejecting the entire claim of so far as 414 lots are concerned, which included the 18% interest, and we have reduced it to 440. If your lordship is rejecting that and modifying that order, then it is.
I'm not modifying it. I'm only saying as per the decree, this is it. You want to get it, you reviewed or do whatever you like, you can do
No,
it before that. court.
we need
No,
not-
I am saying you can do very much with that court.
My lord,
With the court who passed the order seeking a clarification, you can very well do that. That is your lookout.
no, I'm not.
I am, as per me, this should only include this.
So my lord will only record my submission to this.
Yes, yes,
And
I will record,
definitely then
but
your
you,
lordship,
but you give me a better
I'll
calculation.
I'll give you.
Only for that.
I'll
It is,
give-
this calculation is not required. Means this is only just you have given it.
No,
I want the
it's on the
calculation.
basis
Otherwise,
of-
the entire
My
thing
lord,
I
this
will
is-
have to do it.
This is on the basis of calculation given to us by the RBI, by the Chief Manager, State Bank of India.
No, he has done it properly. Otherwise, everything seems to be very. It's
Yes.
okay, but it has been done on 34. So if you can get it done on 25.
That only thing is in lordship order, your lordship may clarify that. Your lordship has
Yes,
asked
I
me
will
and
say that he will be only entitled to this
Fine.
on the basis.
Fine.
And if he doesn't show anything, I'll pass that order.
Fine.
When?
bank rate is there in the RBI website. There, 6.25,
When?
2003.
Could you see before this call? Bank lending rate.
Bank rate.
Bank lending rate. No, there is a different rate.
Well, that is why I say.
Mr. Batra, kindly make it very clear. There is a difference. As on 2013, I also know in the savings bank account, you used to get 6.25. This is the rate. I am only not concerned with all other things. I am only concerned with the bank lending rate as per the IRDA regulation. If you show something else, I'll admit. As per the IRDA, show me on those lines. If it is not there,
Here-
we have to
here-
accept whatever
here-
he says.
Here, one submission possibly Lord will kindly consider. IRDA says bank rate. IRDA doesn't specify or doesn't publish any rate. IRDA is a regulation which says, my lord, in case there is a delay in payment, it is an insurance regulatory development authority. They say in case there is a delay in payment, in terms bank rate prevailing at that time, you will get 2% of the bank rate. IRDA as such doesn't specify. They are not the authority. They are not the bank. They are not the RBI.
Here the court specifically used the word lending rate.
Yes. No, man. That is why.
No.
That is why the one lot of kindly, my lord.
There's no clarification required. I have understood the clarification here. Unless you show me something, I'm giving you an opportunity. Don't show me.
I
Mr.
will show.
Mishra, you give him a better calculation. I will,
2003,
I will just put a stamp of
Whenever-
authority to
whenever-
what the.
well, before that, Lord will kindly consider before that. 2003, RBI has published their bank rate. That I'll produce, then your Lord.
That is not the bank lending rate. Kindly get me a certificate
No,
to
my
that
lord,
effect that that is the
Madam, that is
IRT.
why. Madam, that is why.
Mr.
Lord will
Mozu-
kindly
No,
consider
Mr. Mazumdar, all
one,
this,
one submission. madam.
absolutely no, absolutely no. These, all these submission, you keep it reserved to be made in the Supreme Court.
No, Supreme Court, this issue is
No,
not
no,
there, my
no,
lord.
no. When I dismiss your petition,
No,
you
madam.
go and get it.
Side by
Other,
side.
no,
My lord,
absolutely,
Side by side.
no.
Kindly consider one thing. madam.
Okay,
We have
then I
filed a
do one
review
thing.
petition also.
Let me go as per 34 only.
Even my lord, the-
I'm going as per 34 only.
my lord,
Chalo.
even the certificate that
Lending rate is also less, my lord. That also not been considered. The lending rate they have given.
Unless you place, you
I'll
want,
place it, my
you
lord.
want to place it, but
I'll
I'm not
place
going
it.
to stay anything.
My lord, I'll place
When do
it.
you want it?
Which
And
time-
put it by way of an affidavit that that is the bank lending
Yes,
rate
yes.
for so and so as per IRDA as on so and so. Put it on affidavit.
Yes, please.
When?
Lord, keep it there. 1 week time. Let it run fast
This court, huh?
or any.
It's court.
No, first will be difficult. 27, 28.
No,
will be,
20, 28, I'll
okay.
be out of it.
First, I have a matter.
Mr. Mishra, I have not said anything. I have not touched the year.
No,
now.
no, I'm not.
I'm not on that. You can go ahead with the execution. If they delay, that's their lookout. They want an opportunity out there.
Well,
As of now, I'm
I'll
telling
produce that document, then you'll not be fine.
Second, you want.
Mr. D. Mojumdar, the learned counsel appearing on behalf of the appellant, on behalf of the petitioner, submits that a perusal of the order, judgment and decree passed by the learned this court in RFA number
40 will not pay.
40/2013, dated 27/11/2015, specifically mentioned that the plaintiff would be entitled to interest at the rate of 2% above the bank lending rate as per the IRDA regulation with effect from the date of institution of the suit, that is 13/3/2003, till realization of the full and final amount. Mr. D.K. Mishra, the learned senior counsel, places before this court a set of calculations, including a certificate issued by the chief manager of the State Bank of India, stating inter alia that the prime lending rate, a benchmark prime lending rate as with effect from 4/2/2013 was 14.45%. And it is on the basis thereof the calculation has been made at 16.45% as per the judgment and decree passed by the first appellate court. On the other hand, Mr. D. Mojumdar, the learned senior counsel appearing on behalf of the petitioner, submit that the bank lending rate is one thing, whereas the bank rates as stipulated in by the IRDA regulation is another thing. This court is not convinced with the said submission unless there is some materials brought on record to show that the bank lending rate as per the IRDA regulation is different from the benchmark prime lending rate as stipulated in the certificate dated 9/3/2013 of the State Bank of India. Under such circumstances, this court grants an opportunity to the petitioner to take grant an additional opportunity to the petitioner to place such documents as well as to advised in respect to show as regards the bank lending rate as per IRDA regulation. Underline, bold. List the matter again on when?
Second, second.
No, Tuesday. These small matters are not for Tuesday.
Then third,
third of. So the said documents submitted, I'll put it on record, or you want to put it by way of an affidavit, this
if
document.
your lordship, wants,
Let
you
me
can.
put it back. I'll just keep it, you have a
But
copy.
I have,
And take this, make it on 20,
Yes,
20.
yes.
The matter is fixed there on 30th, so not till then.
In the meantime, the executing court may go ahead with the execution and attach here. Should I put that line?
Just
Till
coup-
then,
Couple of days.
All right.
don't ask all these things. Hey, last line to Nalai.
In the degree of the trial court, when this language itself is not correct. IRDA doesn't.
You should have told the court
Well-
when you had appeared in the RFA, that this language is not correct. And when you have now filed the review, tell the very judge that we look here, the language which you have put is not correct.
Correct.
Don't say all these things
So
before
we
me.
have said in the review, man.
Huh?
In the review, we have said.
Let that court then
More
consider.
than 1 year is lying in defect. I have given your lordship the papers.
No, that day I did one thing. No? As regards a RERA defect matter, I took it up. This particular lawyer, what he has done, he got an order against him in RERA. Appellate order has been passed against him in RERA. Then he files the application out here and appeal and tells the RERA authority that we look here, I have filed, this is the filing number. Now in that appeal, he makes a lot of enclosures. None of the enclosures are there. Then certified copy, not even the impugn order is there. No certified copy is there. Then wakalatnama, he puts the wakalatnama signed by the appellant, but his signature he has not put it. Then when the authority, the registry gets hold of him, what is this type of thing? After getting that number, what is all this thing? Then he said, okay, let me correct it. He takes back the file and then he's not nowhere to be seen. Then the registry has to take it up with him. Then on 6/2/2024, he returns the file. Then on the 4 or 5 occasions also he did not. On the other hand, because of this defective thing which has been done, the RERA authorities have stayed everything. They are not doing anything because the High Court is inside. Then the matter, there were various complaints. The matter came up before me. I told him, when are you? Then I got hold of him that he gave me, do you have a certificate? Yes. So immediately I took it and asked the registry to register it. After registering it, I dismissed the appeal on merits. This is how it is to be done.
Our
If these
review-
type of review applications
But
are
our
done. But
review
I am
says-
not there.
But our
Before
review
that,
is
it was
registered.
filed before another court and an order was obtained, positive order saying that execution may go ahead with 6.25. When we appeared, filed an application, the entire thing was brought before the court dismissed. That they have not annexed. They have annexed
Well,
their
this-
withdrawal
why-
order.
Let by not make such submission.
Why?
Dismissal was on withdrawal on the ground that.
No, I'm talking
Review-
about the vacation, my lord, interim order was vacated. Thereafter, they withdrew the petition. And that interim order is not before the court. They have not annexed. We have that.
I know the review, we have asked for review, it is registered.
Wait, in the,
There is no defect in it. My landlord is saying there is not lying defect, it is registered. So without checking
No,
the
no.
record, they are making this.
no,
submission.
I have given a copy
No,
of the
no,
record
no,
to this court.
Let us place it before the Kamala court. It will run.
They have
Kindly have a look
corrected,
at
my
this.
lord, the IA. They have corrected the IA.
No,
Yesterday only.
Review-
Yesterday we took out.
Review is registered, man.
Next page, my lord, the one that we have given. Yesterday from website, we have taken it out. It's showing not properly filed.
It's numbered also.
What is the number of the
It's a
review?
filing 869.
It's a filing number, my lord.
869.
Review filing number, your lordship will see 15269.
No, 869 is the IA,
869 is the IA. IA they have rectified,
not the review.
not review. Second page of this.
Because obviously, most probably there must be a delay. There must be a
delay
delay.
of many
Delay
years.
delay was on a different term. Earlier.
Whatever may be, there is a delay application.
Yes.
That IA has been rectified. To that effect, IA 869 is a delay application, not the review. Obviously, the review cannot be numbered. Review cannot be numbered unless you get the condonation.
Yes.
Then
So, my lord, there is no question of any defect. Review is now IA is numbered. So unless the IA is considered and allowed, review will not be numbered.
Anyways,
Where is the scope of saying the review is not numbered?
you see, the question of whether it is there or not, I'm not on concern. You have to show me on next day.
My lord,
But
I'll file an affidavit. I'll file an.
in breadth and 80 feet in length. As shown in the application. And what order have you got out here when you move?
My lord,
You got a status quo?
status quo was violated. Just
In
over a
returnable
footpath.
date, operation of the impugned so and so, its state shall remain and party shall maintain status quo, it refers to the footpath. Then who is in, you are using it,
I am with you, I have been with
he
you.
is also using it.
Well, actually,
It is-
I am in my possession 1 cut 5 acres land is there. That is my only land, my lord. I am constructing a dwelling house, my lord. I am residing with my minor daughter. My lord, after my lord obtaining that order was civil judge, when civil judge order my lord, set aside the injunction, my lord, I have constructed a teen shali, my lord. Then, my lord, they have challenged that order here, my lord, and status quo was directed to maintain. And my lord, in the meantime, they have filed another miscase before the Munship, my lord, that 39(2)(a), my lord, alleging violation of the order, my lord. In that case, my lord, learned Munship, my lord, depending on the report of the OC concern, ordered to demolish the Tinchali. So that is my only dwelling
Now,
house.
is the stinchali
Yes.
impeding in the right of way?
My lord, that is my patta land, my lord.
Understood. Patta land is there, but whatever may be, he is using out there for the last so many years. He said,
Road they have one, my lord, in the midway of the, my lord, patta land.
how much is your land?
1 cut 5 acres.
This is the entire land.
Yes, ma'am. No,
So
no,
you are-
not
It is a
entire
well-
land, my lord. In the middle portion of the land.
His land is 10 feet by 80.
Yes.
Which means 800 square feet.
800 square feet.
800 square feet will
In
be
the
around
middle
4
portion.
acres.
In the middle portion.
It is how much? 6 acres. 6 acres of land.
Yeah.
And the total land out there is, so you are having, and you have made the layer on the middle.
My lord, Insali house is there, my lord. Land is, my lord,
You did not build anything prior to that.
no, my lord. No, prior to that, there was a house, my lord, the depleted stage, my lord.
So on the side.
Yes.
So on the side, have it built it out there. You have built at
But
the time
the-
knowing it when there is an order being passed by the court.
If the, my lord, road is
When was
allowed,
the order passed?
my lord,
You kindly see the order was passed by the learned trial court, first appellate court on 16/5/2016.
my lord.
He got the status quo on 17/6/2016,
Hello.
meaning by within almost 1 month.
Hello.
In 1 month, what you have constructed must be in a very, not in a proper manner.
Insali, my lord.
So remove the Tinchali from there to nearby where you were having the dilapidation.
My lord, if the road is allowed to go, my lord, then the land will be, my lord, two part, my lord, land will be. That is why.
That will be decided in the trial as to whether he has an easement right over that.
And I approached this, my lord, honorable court, challenging that the demolition order only because that the status quo order was passed by this honorable court. So they could have, my lord, file any application before this honorable court. Because, my lord, status quo order was passed by this honorable court.
Okay, we pass that order. We take it
I have
on.
an objection so far as the second case is concerned. But against the same order, he had also prepared an appeal before the appellate court
That
against
was-
the against the demolition of construction.
Yes, that was
1/10/19. That
Then
is
what
the
happened?
impugned order.
against the, along with the appeal, I have also filed a stay petition. That was dismissed and appeal was pending. If my lord stay is not, in the meantime, if the,
What has happened to the appeal, I don't.
so I have challenged, yes, appeal is still pending perhaps. So far I know.
No, understood, but what do I do? First of all, the court, the appellate court made that mistake. You constructed. I think you remove it from there to some other place nearby. Earlier where you were having the dilapidated house. This court is not going to interfere with that earlier order. That order passed by that Munshi. You knew it very well. Immediately you have constructed. You have never constructed earlier on that path.
My lord, earlier there was a suit, my lord, filed by the elder brother of the present petitioner, my lord. They have filed a suit, my lord, checking, my lord, the suit was filed by the predecessor because they were claiming, my lord, possessory right. So, my lord, the predecessor of the present petitioner, they have filed a title suit that was decreed. They have preferred appeal. Appeal was dismissed. Now, my lord, another brother filed that title suit seeking, my lord, that easementary right or alternatively, my lord, ownership on adverse possession. So that is my
Adverse
only land, my
possession,
lord.
in fact, adverse possession is another. My opinion, adverse possession cannot be a case of adverse possession because of the fact that when you are asking for easementary right and adverse possession, both are completely contradictory.
And they are having alternative road, my lord. They are having alternative road to my instruction, my lord. I have stated in my petition. When that title appeal, their appeal dismissed, my lord, they have, my lord, hence their whole land, 1 kata 5 land.
And what has happened to the suit?
Suit is, my lord, filed by present petitioner, my lord. That is pending, my lord.
Yeah. Huh? Why 2013 suit we are in PWD after 11 years?
During my lockdown period, the court was not available. And now,
Only for 2 years.
no, my lord, the court was not available. And it is
Which
not
court is this? There's no civil judge, Dorong, Mongoldo.
Munsif,
available.
Munsif.
In the
Huh?
morning, my lord,
So, my lord,
There's no Munsif.
so, my lord,
There's
my
no
prayer will be,
Munsif
my
number
lord.
2, Dorong.
So, my prayer will be, my lord. As my learned friend already submitted that they are still using the loan, land, my lord, road, my lord.
Are you still using the road?
Because of the obstruction. Because of the construction.
Have you filed any application for that?
I filed an application for the London Trial Court under Order Section Rule 2A. And in that case,
It has been asked to demolish.
So, allegation, my lord.
against that order, they have prepared an appeal and the injunction application,
No, you
the
make it
application was
thereafter.
rejected, thereafter they came.
My lord,
It's rightly done. Anyway.
my lord, my lord, just a minute, my lord.
BC does, huh?
1 minute, my lord. My learned friend said that I have obstructed in the year 2017 and they are residing there. But still, there is an alternative road that has been used by them, my lord, till now. Without any road, my lord, they cannot reside there. So there must be any alternative road, my lord.
Yes, Mr. Kaim. You are staying inside or you have left your place?
using the that side some other land.
Huh?
We using that side of some other resident.
Other.
Other.
So tomorrow you are again going to claim easementary right about others.
My instruction was that if they are property, we sold the land and if they are ready to purchase the land, otherwise we have to opt.
But what are you doing from 2016?
Because there was a dispute that they using the is called for that side of the other.
We do one thing. Let the status quo in respect to the path be maintained as per this order. And I'm not going to interfere with that order. I think then whatever the trial court does. Because you have constructed, knowing you, Mr. Kolita, you have been very clever.
Well,
You shouldn't have done that. I would have understood thereafter you have constructed.
because that was depleted state. So
So why did you construct on that path when there was an
one
application?
cut of 5 less, my lord, no other land, my lord.
You have land. He is only claiming 800 square feet.
In the middle portion, my lord.
Earlier,
that is
what
the
were you
difficulty.
doing? Earlier, what was happening?
Earlier, my lord, when they fail, my lord, to take possession of that land, they come with this petition, my lord. In earlier proceeding, my lord, title appeal, they
So
fail.
let the status quo be maintained as it is. But I'm not going to take status quo as on
As on
17.
today, my lord, let it be maintained as on today, my lord.
As on 17.
Because 2016, they are
17/6/2016. And if the trial court has found that after this order you have constructed, then it has to be demolished. If there are finding to that fact
Yes, yes.
that he has constructed after
Yes.
17/6.
My lord, I have annexed the Mondal report, lordship.
I
kindly
have
see, my lord.
Mondal report is for
In my
Mondal to see.
petition, my lord,
Where's
was
the-
no
where's the
road, my lord.
direction?
There was no road. Kindly see, my lord.
No.
Page
My
82, my lord, in my
order
petition, my
says
lord.
the direction of maintenance area was landed
Page 82, my lord. In my petition.
You constructed a wall also.
Yes.
No, my lord, I have annexed, my lord, photograph. Kindly see, my lord.
No.
Page 83, my lord. There is a photograph, my lord. I have annexed the photograph, my lord. They are using this road, my lord. Still.
Lahore. This is an application under section 115 of the Code of Civil Procedure. No, no. Both the petitions are taken up together for disposal by this common order. Let this court first take up CRP number 199/2016. This is an application filed under Article 2 to 7 of the Constitution challenging the judgment and order dated 16/5/2016 passed by the learned civil judge Dorong Mongoldoi in Miss Appeal number 3/2015, whereby the order passed by the learned Munsif number 2 Mongoldoi in Mize case number 6/13 arising out of title suit number 7/2013 was set aside. A perusal of the record reveals that the plaintiff, the petitioner herein, who is the plaintiff, had filed a suit being title suit number 7/2013, stating inter alia that he owns and possesses a plot of land measuring 2 katha 6 lechas covered by patta number 390/104 new and dag number 571/797 of village Mongoldoi town, ward number 5 under Rongamoti Moza. Over the said land, the plaintiff had 3 houses, and the plaintiff lives in the said house along with his family members. The said land has been more specifically described in Schedule A. It is the further case of the plaintiff that the Schedule A land was initially occupied by his father in the year 1951 along with his 3 brothers. His father expired in the year 1983. It was also mentioned that there is a municipal road running from east to west situated towards the north of the land of the plaintiff, where the plaintiff is residing. There's an approach road measuring 10 feet in width and 80 feet in length from the land of the petitioner, plaintiff, to the municipal path. The said land has been specifically described in Schedule B to the plain. It was the specific case of the plaintiff that the plaintiff used the said land, said road, specifically described in the Schedule B for the last 62 years, along with his father, as a path for going from their house to the municipal road. The respondent, the defendant, the predecessor of the defendants, however, did not disturb the use of the said suit path. However, the defendants, after winning a suit, being title suit number 38/98, filed against one Manoranjan Day,
Brother of Robin Day.
the brother of the plaintiff. They claimed to be the absolute owner of the land, including the land covered by suit path. It has been stated in the claim that the defendants started disturbing with effect from 1/9/2012 Under such circumstances, the suit was filed declaring that the plaintiff had an easement right on the suit path described in Schedule B, semicolon, for a decree declaring that the right, title, and interest of the defendant in the suit path, if any, has become barred by adverse possession, and further decree declaring that the plaintiff is the owner of the suit land on account of adverse possession, and for permanent injunction restraining the defendants, their servants, employees, or any person at his behest from doing any act of obstruction of the suit path in any manner and or raising construction over raising constructing any house structure and obstructing the plaintiff in any way from using the path. Along with the suit, an injunction application was filed on the similar facts, seeking injunction, which was parameteria to the prayer. A permanent injunction sought for in the suit. The said injunction application was registered and numbered as case number 6/2013. The learned trial court, by an order dated where is that order?
For the 26/3/2015.
Where is that order?
In my petition, page 23.
One petition here.
87, Your Lord.
Huh?
87.
87.
87.
The learned trial court, that is the court of the Munsif number 2, Dorong, by an order dated 26/3/2015, directed both the parties to maintain the suit path in status quo. Apart from that, the parties were also directed not to make any structural changes in the suit path by way of any construction, digging, etc. The parties were also directed not to damage and alienate the suit land by way of sale, mortgage, transfer, lease, pledge, etc. till the disposal of the main suit. Being agreed, and an appeal was prepared by the defendants. which was registered and numbered as Miss Appeal number 3/2015. The said Miss Appeal was dismissed, was allowed by the order dated 16/5/2016, thereby setting aside the the order passed by the learned trial court granting injunction. The reason why the learned first appellate court interfered with the order is that the plaintiff have claimed their right over the suit land on the basis of adverse possession and not on the basis of title and possession. And as such, the plaintiffs did not have a prima facie case. It was also opined by the learned first appellate court that if the defendants are directed observe that if the impugned order, if the order of injunction passed by the learned trial court is not interfered with, then the right and interest of the defendant along to enjoy their suit land would be interfered with. Which can be said to be in the form of a temporary injunction restraining them from using the land. It was opined that this would affect and curtail the right of the opposite party defendants in enjoyment of their property. Accordingly, on the basis thereof, the order passed by the learned Munsif, learned trial court dated 26/3/2015 passed was set aside and quashed. The said order passed by the learned first appellate court dated 16/5/2016 were challenged in the instant proceedings by filing the instant application by filing CRP number 199/2016. On 31/5/2016 itself. The matter thereupon came before this court, and by an order dated 17/6/2016, notice was issued. And this court further directed that till the returnable date, the operation of the impugned appellate judgment and order dated 16/5/2016 passed in Miss Appeal number 3/2015 by the court of the civil judge Dorong Mongoldoy said remain state, and the parties shall maintain status quo with respect to the suit court. The record reveals that the interim order which was passed was continued thereafter until further orders. Full stop. This court further finds it relevant to take note of the subsequent events which ensued thereupon pursuant to the order passed by this court. On 17/6/2016, an application was filed by the petitioner herein under Order 39, Rule 2A, read with Section 151, before the court of the Munsif, before the learned trial court, alleging violation of the order dated 26/3/2015, passed in Mize case number 6/2013, as well as the order passed by this court the record further reveals that in the said proceedings, various applications thereupon were filed from time to time, seeking direction, alleging that the respondent herein, alleging that the defendants have put barricades and concrete wall on the suit path, and to restore the suit path as on the date of passing of the status quo order. The learned trial court, by an order dated 1/10/2019, taking into account that from the materials on record, it appeared that the defendants have violated the status quo order with respect to the suit path by making construction over the suit path, and thus preventing the plaintiff and his family members from ingress and egress through the suit path. Pass the direction for restoring the suit path to the original position as it stood on the date of the status quo order. Accordingly, consequential directions were passed, thereby directing the SP Dorong to execute the order in presence of adequate number of police personnel, the circle officer, Mongoldo Revenue Circle, and his required staff, to prevent deterioration of any kind of law and order. This order dated 1/10/2019, passed in Mize case number 15/2016, was put to challenge by the defendants in no, absolutely. Direction. It is also apparent from the records that on 4/10/2019, an application was filed by the defendant before the learned trial court seeking stay of the directions which were passed on 1/10/2019. Where is the remaining part of that order? Page 60.
That part is skip. Last.
The order 41 rule 5, na? (24/10). 4/10, huh? 4/10/2019. On the ground that the defendant could prefer an appeal. Thereupon, the defendant preferred an appeal before the court of the civil judge, Dorong Moldoi, challenging the order dated 1/10/2019, which was registered and numbered as Miss Appeal number 7/19, which was admitted for hearing. Full stop. However, no stay was granted. However, the directions which was passed on 1/10/2019 passed by the learned trial court was not stayed by the first appellate court, as could be seen from the order dated 23/10/2019. And also, the application for stay was rejected. Being agreed. Full stop. The learned, no, full stop. It further appears that the learned trial court thereupon proceeded, passed the order on 24/10/2019 to proceed with the execution of the order dated 1/10/2019 and fixed 19/11/2019. Under such circumstances, the defendant, as petitioner, has approached this court by filing the second proceedings, that is CRP IO number 377/2019, challenging the order dated 1/10/2019. And 110/2019, as well as 2310 passed by the Learned Trial Court and 2310/2019 passed by the Learned First Appellate Court, whereby the stay application was rejected. This court have duly heard the learned counsels appearing on behalf of the petitioner, on behalf of the parties in both the proceedings. What is this page 14, annexure 14, page 83?
Page 83, my lord, the photograph of the, my lord, that passage, my lord.
Where is his house?
My lord, this
Plaintiff's
left side,
house?
this
Huh?
Torza wall, my lord, this Torza wall left side.
Where is the plaintiff's house?
Plaintiff's house, my lord, plaintiff's house, my lord, perhaps back side,
Which side?
this side perhaps.
So this wall has been broken.
Yes, my lord, it is broken, my lord, it is not newly constructed. Wall was not newly constructed. Wall was constructed when the earlier litigation, my lord, that to 2012, my lord.
And
Appeal was
okay,
dismissed then, my lord.
no. Then where the plaintiff's house is this? And if you go straight, there is some house out there. What is that? Yes, Mr. Kaim. What is this photograph?
Cannot understand, my lord, what is the, my lord, my house and what is the picture. He can understand. My, it's not about the, my lord, political picture.
And what do you use this 10 feet road for? You have your car. You use it as a passage. So we pass an order that under no circumstances the ingress and egress of the plaintiff should be disturbed by them during the event. You take out some way or give some way. I'm coming. Just think about it. Ask your client. Follow up. Whatever may be. If it cannot be demolished, it is okay. But if it has to be demolished, it should be. But ingress and egress of the plaintiff should not be disturbed during the pendency. You find out a way. Come up. Amounts to violation of the orders passed by this court, and as such actions which have been done, such constructions, if any, carried out. More so during the pendency of the suit, have been rightly directed to be demolished by the Learned Trial Court in its orders referred to above. Be that as it may, this court, upon hearing the learned counsels for the parties, is of the opinion that the ingress and egress to the petition of the plaintiff through the suit path, that is the Schedule B land, is required to be maintained during the pendency of the suit. Under such circumstances, this court disposes of both the petitions thereby directing with the following directions and observations. Number one, the order dated 26/3/2015 passed by the learned trial court in Ms. case number 6/2013 is restored. The order passed by the learned first appellate court dated 16/5/2016 passed in Ms. Appeal number 3/2015 is set aside and quashed. Next. This court is not inclined to interfere with the orders dated 1/10/2019, 4/10/2019, and 24/10/2019 passed by the learned trial court in Ms. J case number 15/2016, as well as the order dated 23/10/2019 passed by the learned first appellate court in Miss case number, Miss Appeal number 7. Huh? What is the number? 7/9. As well as the order dated 23/10/2019 passed in petition number 2016/19 arising out of Miss Appeal number
7/2019.
7/2019. Full stop. Next. This court further directs the learned trial court to cause a commission in terms with Order 39, Rule 7 of the code, and thereupon ascertain as to whether the ingress and egress to the plaintiff's land described in Schedule A to the plaintiff could be the ingress and egress of the plaintiff to the plaintiff's land in Schedule A of the plaintiff can be effected without demolishing any of the structures. Full stop. On the basis of the commission report, if it is found that the same can be done through without any demolishment, without any demolishing of any structure, the learned trial court shall pass appropriate orders in that regard. It is clear, however, it is observed and directed that the learned trial court shall also, while passing the order, take note of that there should not be any in addition to that, this court further directs the officer in charge of which police station? Mongoloi police station, as well as the circle officer of the Mongoloi Revenue Circle to aid, to do the needful so that the orders passed by the learned trial court for granting ingress and egress to the plaintiff through the Schedule B land to the plaintiff Schedule A land from the municipal pot remains undisturbed during the pendency of the suit. Full stop. Anything else? Nothing more. Mr. Koilta, kindly advise your client to give some way.
Yes, my lord.
If it is not done, you will be more in trouble.
Yes, my lord.
LCR go back. So, I will tell you, before parting with the record, this court duly takes note of that the suit has been pending from 2013 and almost 11 years have passed by. Under such circumstances, this court directs the learned trial court to dispose of the suit at the earliest convenience as per its business and preferably within a period of 6 months. In that process, if necessary, the proceedings of the suit be taken up on day-to-day basis.
All right.
May I please, your lordship?
Hmm.
Lordship, due to the expiry of respondent number 2 and 4, I have for substitution of legal year filed on 21/2/2024, but this has not come to the record. So registry may kindly be directed to take the IA record.
Why the application so filed, you have filed it defective? Why?
Okay, my lord,
How many times have you visited the office, the registry?
actually, my lord, my senior is out of his.
Forget about your senior. Who has filed it? Who has filed it?
Me.
Then, why is it defective? We dismiss the suit appeal on that ground.
My lord, my senior is-
2007 appeal, we are not going to allow it to be delayed by this. When did the person die?
In 2020.
2020. Then?
Actually, lordship, my client informed me in November 23. Immediately, as per
You
instruction of
informed
the
him.
Honorable Court, I
Then? Why are you keeping it defective? There's a stay. Stay is going on.
Yes.
We vacate the stay. You'll pass.
I don't think a short break may be granted. My senior is out of it.
When? The learned counsel appearing on behalf of the appellant submits that he would correct the defects during the course of the day today. The matter be listed again on 28/4/2024. If it is made clear that if the defects are not corrected before that, then in such circumstances, the stay which has been passed by this court in Miss case number 1711/2009 shall be vacated. Don't take things for granted, Mr. Counsel. Next time is cost. Madam, LCR has been received. Other side is appearing.
That's the problem. My other side is not appearing.
Why?
So I will take your lordship. Here, what happened on 23/11/2010? Name of the respondent number 2 to 11 staff house. And 1611 LCR received service completed before hearing on 28/11. 28/11 might have listed on 9/8/11. On 29/5/15 minute, appeal dismissed. And thereafter, by that we enter appearance, we file application for restoration of the appeal. Accordingly, by the order dated 27/19, madam.
Madam, it's a case of remand. Was it remanded?
Uh, maybe.
In appeal, it was
No,
remanded.
no, I will
Let's
take
see
your,
the impugned
I
order.
will,
No, let us see the impugned order.
yes, once it is remanded, my lord.
Well, is this a case of remand?
Uh, it is.
Madam, if it's a case of remand, then how are you maintaining a second appeal?
My lord. Yes, it was my lord, title appeal 19/7 was remanded, my lord.
So if it is remanded, how are you maintaining this second appeal?
Second appeal lies, my lord, I will satisfy your lord.
No, let me be satisfied in 2 minutes. Kindly come to order 43. Rule 1U.
Here, what happens, my lord, service is not complete, my lord. I feel also permits me.
No, madam. Kindly come. Unnecessarily, why should we deal with this matter? This is unnecessary. 2008, the suit has been stayed unnecessary. Kindly come to order 43, rule 1U. 2008 matter. What did he say?
Appeal from order. And appeal shall lie from the following order.
1U.
An order under Route 43, 23, or order 41 remanding a case wherein appeal would lie from the dictate of the appellate.
See? It's a SAO.
Well, your lordship may take up the matter on another day, but I will go. Because here, my lord, I was ready on that point, my lord, because no one appears for the respondent. My lord. And last order, my lord, if your lordship permits me, it may also do that.
Who is appearing in this matter for the respondent?
My lord, earlier, my lord, Ken Pranal and appears.
Now he has become a judge. You
Yes,
can't help
my
it.
lord. Yes, sir, my lord, on the last order, I will take your lordship to it, my lord.
Hmm.
On 27/11/2019, my lord. Here it says, hence it is submitted that respondents have the notice to appear in this appeal. Be that as it may, as it is required that respondents be put to notice of hearing of the appeal, this court is inclined to direct the appellant to take steps for service of notice on the respondent by usual process, as well as by registered post which ready within a week from today. The next notice is made returnable within 4 days. Thereafter, we take steps. Thereafter, on 9/12/2022, here it says, so LCR is received as the matter is old pending, registry is directed to verify whether Mr. P. Khatonia, learned counsel for the respondent, is interested to pursue the matter. This is the matter after vacation. Thereafter, the matter came up on 22/01/2023. It was fixed on 7/2/2003. Thereafter, the record is cited.
Madam, we'll take it as the respondents are there. We will do one thing. We'll have it on 27th, 28th, 28th, 28th. We'll dispose it of. Release the matter on 28th March 2024 for further hearing on the matter. We'll convert it to an SAO and then we'll see as to whether it is a case of remand or not. And then whatever needs to be either set aside or done, whatever maybe it has to be done now. Who is appearing for the plaintiff petitioner?
Senior counsel PC Diocese.
Whether the decree passed by the court below declaring the title of the over the suit plan is unjustified and illegal because a part of the suit plan measuring 1 kata is covered by invalid, the plaintiff has no right. This can't be a substantial question of, isn't it?
In fact, my lord, the decree has been executed. Therefore,
That is why nobody is appearing. No, none appears on behalf of the appellant on call. Mr. G. Bhardwaj appears on behalf of the respondent.
number one.
Huh?
Respondent number one.
Respondent number 1 and has submitted that the decree has already been executed. So taking into account that none has appeared on behalf of the appellant and also on the earlier occasion also, the instant appeal stands dismissed for non-prosecution.
Hello.
The record, the LCR be returned by the court, by the registry to the court. LCR of PA has been received, but LCR have not been received. No affidavit as regards steps upon 17 and 18.
Sole appellant expired on 17/4/2016.
Who?
Sole appellant.
You are the sole appellant.
No, I'm for the respondent.
Oh, you died.
Yes, 8 years back.
On?
He has expired, but the legalizers are not aware of the fact of the case.
On?
In the 17/4/2016. In last 8 years, no certificate. Stay is also there. Since
It
2000.
has been brought to the notice of this court that the sole appellant in RSA, in both
Both.
sole appellant, it has been brought to the attention of this court that the sole appellant had expired on
17/4/2016.
17/4/2016, and thereupon no steps have been taken as is required under the provisions of Order 22, Rule 3 of the code. Accordingly, the appeal stands abated. And
They were not aware of the pendency of the case.
TRP same abated.
Which
and
time
closed.
may be granted to
Stay-
take steps.
Stay order may be vacated, Lordship.
Stay orders stand. You know what to do. I have,
They were not aware of the pendency of the case.
you know.
We are not aware that he has died.
How did you know now?
Just yesterday this has been listed, so we have
You
contacted the
contacted.
nearby relatives. Thereafter we have
Can't be like that. For that, you need to file something.
Lordship,
One additional day, it cannot be.
Lordship, 3 weeks time you are.
Sorry. Good. Yes, what is this?
There is an order for
You have not taken steps by Dusty?
Yes, Lordship.
Huh?
The notices were taken thereafter. They have not contacted.
Who?
The
Appellant. To you.
yes, sir. We have
Don't
also
appear. We
several-
dismiss for default. None appears on behalf of the appellant on call. Appellant or petitioner?
petitioner.
This case for what?
This is for delay condonation application.
Huh?
This is delay condonation application. I am for the petition.
Okay, none appears on behalf of the petitioner on call. Please, matter again on
I am appearing
8th of
petition.
You are saying that you have no instructions to appear.
No. They have taken the notices, thereafter they have not contracted. I have also contracted with the local layer, but no response is forthcoming.
From the appellant.
Yes.
That is why I'm saying you have no instructions. So you don't appear. We'll have it on some other day on 10th. We dismiss for default this matter. Unnecessary matters should not repeat. Okay, tell me one thing. How much is the delay? 222 days.
220.
Hello, we dismiss it on that ground only. What is the ground?
That is 225 days delay.
Judgment passed on. That he went to Morigaon and visited. Yeah, when was the judgment? The appellant begs to state he prepared the title appeal number 16 of 2021 challenging the judgment and decree dated past by between the two. Learned producers Morigaon after hearing the by judgment and decree dated this appeal by and particularly period the applicant to have filed and in that way you can we dismiss. This is an application on the section 5 of the Limitation Act seeking condonation for delay of 222 days in preparing the accompanying second appeal. It is relevant to take note of that this court, by an order dated 31/2015, had issued notice. Till date, no, the service have not been completed, have not been effected upon the respondents. It is also relevant to take note of that the petitioner was also directed to take steps by way of dusty upon the respondent. However, no such steps have been taken by the petitioner till date. Under such circumstances, this court therefore takes note of as to whether the incident application at all requires to be taken into account. Had required incident application seeking condonation of delay is at all required to be further pursued, taking into account that no steps was taken by the appellant petitioner, in spite of there was a direction. The record reveals that on 10/10/2023, the judgment and decree was passed by the learned First Appellate Court in title appeal number 16/2011. Thereupon it revealed that the petitioner, the appellant, the applicant, came to learn about the said judgment and order on 31/10/2023. The record further reveals that a certified copy of the said judgment and decree was applied on 7/11/2023, and on the same day, the same was received. Full stop. The record further reveals, the said application further reveals that thereupon the petitioner, the applicant, have been only taking steps for discussion as to whether to further pursue the filing of the appeal, in spite of the fact that the learned counsel to whom he sought advice informed him on 10/11/2023 itself that he should prefer an appeal. Full stop. It is also mentioned that the applicant was also suffering, was also suffering from some certain illness. Full stop. This court have duly taken note of the medical certificate which have been enclosed to as Annexure A, and from the said application certificate, it has been also only mentioned that the applicant was suffering, was under treatment and medical advice, and he was advised for complete rest for 1.5 months with effect from 12/12/2013. Full stop. Thereafter, also, the applicant did not file the instant appeal. Rather, the appeal was filed on 21/8/2014. So under such circumstances, this court does not find this application to does not find the grounds assigned in the application as sufficient grounds for condoning the delay of 222 days. Accordingly, the instant appeal stands dismissed, rejected, and instant application stands dismissed. Full stop. It is also observed that in view of the dismissal of the instant application, an instant application stands rejected. Also, it is further observed that in view of the rejection of the application to condone the delay, the accompanying read second appeal, which is yet to be numbered, cannot be entertained, being barred by limitation.
Instead of 23, with 13. Lord.
What?
Year. Lord.
Yeah.
Year, Lord, it was 23. With 13. Lord.
Or 2020.
Public.
My goodness, they pay for what? Yeah. None has appeared on behalf of the applicant on call. Full stop. The record further reveals that on 18/2/2020, it was duly informed to this court by the counsel appearing on behalf of the applicant that the respondent number 6, 7, and 10 had reportedly expired, for which there was a necessity of filing an application for substitution of the legal heirs. Full stop. The record further reveals from the office note dated 22/3/2024 that there has been no application filed for substitution of the legal representatives. Full stop. Taking into account the above, the instant application stands abated in view of the death of the respondent number 6, 7, and 10, in view, more so in view of the fact that the order passed by the learned executing court in exercise of the powers under Order 21, Rule 97 and 101, being a decree, and the said decree is not severable. I therefore stands abated and closed. Yes,
Application under order 41 to 19 for de-execution of safety.
then how many people have died?
So it's a re-admission of achievement, order 41 to 19.
Understood. Are you aware that the one respond number 1 and 3 had died?
So it's not reflect.
Huh?
Not ever.
It is clearly given in the office of Lozima Court's order of 3/12/2019 that as per office order dated 2 process service shows respond number 1 and 3 had expired. Respond number 2 was not found and known in the locality. Notice upon the respondent number 4 has been served. Peruse the officer's service is complete as regards to appellant side may file another application for substitution of the legal heirs of respond number 1 and 3 if so advised. And the appellant is further directed to take steps. That was in 2019. You have not done anything thereafter. Tell me. Again, the same order has been repeated. Again, the same order has been repeated. You are not interested. Why should one restore? Well,
Within this week.
you want this to be restored? 2007 matter. Let us see. You have a case or not. Whether the courts below erred in law in deciding the issue number 5 and arriving at a wrong decision in view of the earlier revenue auction sale of the suit land in favor of Iman have already been set aside at the instance of other pattadas and thereby refusing relief to the plaintiff in spite of the decision only in their favor.
The food land was put on auction. The food land was put on auction. Then, and then number 1 has purchased the auction sale. Subsequently, that auction sale was settled before the revenue. That was set aside. And thereafter, my lord, the record has not been corrected. In the meantime, my lord, the defendant number 1 has gifted one portion of the scheduled land, my lord, to the defendant number 2. That gift has been finished. Ultimately, the
But it was dismissed for default in 2018 and till now nothing has happened. What to do? Tell me. You are not interested. It seems that you are not interested. You are the counsel. Kindly see your order on 1/2/2000. I heard Mr. Tiladitya, the learned counsel for that. It is seen as per the office that the process server has reported response was not found. Accordingly, the learned counsel granted 3 weeks time to ascertain the correct address of Iman and take appropriate steps. Yeah, what to do? You're not serious. Are you serious? No. Your clients must have also left hope. They must have left hope. Because if a restoration application is to remain pending for 6 years, what to do? Come one day, the grandchildren also will come up. The children, to forget about the children, the grandchildren will be now become the legal representative because of your conduct. You're not interested. Why you pursuing unnecessarily litigation out here, keeping one matter pending? Tell me. 6 years, is it a matter of joke? Huh? When the order is there, you were supposed to take steps. Did you take a steps? No. Not even upon the respond number 2. Tell me. If you are not serious with this matter, how do I do it? The advocate's name whose name was reflected, he has also died. Isn't it?
The problem is that my the long pending matters, my clients,
The clients must have forgotten that there was any case. Ask them whether they are serious with that. We'll have it on first. On first, we keep it. In the meantime, if you want, you take steps. I'll have it on third. I'll give you. You want to take steps? Take the steps by filing an application for substitution of 1 and 3, and also take steps upon respond number 2 without fail. And if not, then tell me if the clients are not interested with dismiss. So list the matter on 3/4/2024. So in the meantime, the applicant is given the learned counsel for the applicant shall take appropriate instructions as to whether the applicants are actually serious in the instant proceedings.
Start from.
This was a suit
For declaration and
filed by whom?
by appellant plaintiff. Appellant,
And they participated.
they participate.
How many you lost in the suit?
Our suit was decreed in favor of us.
Appeal filed by?
Was reversed.
There was only one appellant in the
No,
trial, in the first appellate stage.
Lordship.
Why you are making all other people a party?
Aesthetically, because Uttara Burman was at the time, he was the plaintiff. Now
Who?
Uttara Burman has preferred the appeal. This one
No,
Gopal Burman
that-
actually contested.
How many, you see, Gopal Burman was the defendant only in the suit.
He contested.
Why you are making Jiten Burman a party? Dolly Burman a party, Rajan Burman a party, Godan Burman a party. Why?
It was in the suit.
See the memo of appeal.
In the suit, they were names were there.
So they have not filed any appeal.
No, they did not find it.
Now why you are making them a party?
That case, their name also may be be struck off.
They filed a suit
Suit was filed by us.
and the suit was decreed.
Decree.
Then one of the defendants prepared an
Preferred
appeal.
appeal. First appeal.
Once one of the defendant and the decree was set aside.
Yes.
So your appeal will be only against him. Why you are making all other people a
So in
party?
that case, that all those are us 2, 2, 3, 4, 5. Maybe kindly.
Unnecessary because they are not parties out there.
Meanwhile, there is a talk of compromises also.
Huh?
There is a talk of compromise in respect of PCPL lab.
Whatever may be. Show me the plain. Title 2.
Plain that 41 to 46.
Where is the title appeal?
Title appeal at page. There is a lordship, there is a delay. 313 days.
Understood. Why I am saying there is a reason why. Where is the appeal?
Appeal,
Memo of appeal.
memo of appeal, that a copy you have not given.
How are you filing this second appeal without the memo of appeal?
That is only because we
No.
have been filing it only.
The memo of appeal has to be a part of it.
In that case, we will be allowed to file that memo of appeal.
Because obviously that is why Jiten Burman is not accepting. His name is Jitendra Burman.
Father, they are actually brothers. Both
So
are
what?
brothers.
He
Gopal
says
and
my
Jiten.
father's name is not Dolly Burman. Dolly
Ram
Ram
Burman,
Burman.
this is.
Then where is the original copy of the plane?
At page 41.
That I know. This is a type copy. Where is the original copy of the plane?
That was actually in that was in the very poor drafting, very poor.
Do you have a copy of
We
it?
have the copy.
To me. This court have duly taken note of the office note dated 26/6/2023, which revealed that the respondent number 3's summons was duly served upon his wife as the said respondent was not present at home. As regards the respondent number 2, the said respondent number 2 refused to accept on the ground that his name is Jitendra Burman and his father's name is late Dolly Ram Burman. On the other hand, this court duly takes note of the copy of the plain wherein the respondent number two's name has been shown as Jiten Bormon, son of late Dolly Bormon. And in spite of that, he had filed a written statement. Under such circumstances, the ground on which the respondent number two have refused to accept the service cannot be tenable, for which this court duly accepts that the service upon the respondent number two is duly complete. This court also takes note of that the service upon the respondent number three is complete. Who is appealing for one?
Nobody has filed local property.
What about one?
Service is complete, but nobody has attended.
It is also seen that from the office note dated 29/11/2022 that the service upon the respondent number 1 and 6 have been duly complete, inasmuch as the same were received by the elder, by an adult member in their family. So accordingly, the service being complete lists the matter again on 8th of April 2024 for consideration of as to whether the delay of 313 days in preparing the accompanying appeal can be condoned. I'm going to read your question. Alage, no, itu theor. Mr. Bhagavati, kindly take that. What is this FAO?
Dr. This FAO was preferred against an order dated 6/1/2020 passed by the learned civil judge 2 in a title suit, in a miss case which we had filed for setting aside the stay order, and it was rejected, and we preferred this first appeal or against order. However, during the pendency of the FAO, there was some negotiations going on between the parties, and in the light of those negotiations, was some instructions from the regional office that this may be withdrawn. So there was order on 24/4/2020, whereby this appeal was closed for withdrawal. But again, there was instructions from the head office that it should not be withdrawn. They did not agree to that withdrawal. So again, we had filed an IA number 1010. So in that, an order was passed on where this this was recalled. The order of 24/4/2020 was recalled. Then again, this was reinstated, and then these negotiations were again going on. And in the light of those negotiations, they have withdrawn the title suit lottery. So
They have withdrawn they have withdrawn the
title suit, original title suit in the civil judge.
So there's nothing remain.
No.
What's your name?
J.R. Thak. J.R. Thak.
Miss So-and-so, the learned counsel appearing on behalf of the appellant submits that the instant appeal arises out of an order passed by the court of the civil judge number 2, Kamrup Metro at Guwahati, whereby the injunction application filed by the petitioner was rejected. The said order was passed in Mizze case number 827/2019 arising out of title suit number 452/2019. The learned counsel appearing on behalf of the appellant categorically submits that the title suit number 452/2019 had already been withdrawn. Full stop.
By the order dated 21/2/20.
By the order dated 21/2/2022. Taking into account that the main proceeding, the suit proceedings are no longer in existence, the instant proceedings had become infructuous, for which the instant appeal stands closed.
Much.
Yes, you have not taken steps upon response number 3.
Lordship, the response number 2, your Lordship, response number 3. Lordship, he is the performer respondent.
You don't want to take?
Lordship, his name is Pistako. Because although he was the original defendant, but he thought before any appeal.
You don't want to take steps upon response number 3.
Lord.
Mr. R.K. Bhuiyan, the learned counsel appearing on behalf of the applicants, submits that he would not, that the applicant would not like to pursue the instant appeal, as well as the instant application, as well as the accompanying appeal against the respondent number 3. He therefore submits that his name, the name of the performer respondent number 3 be struck off. Taking into account the above, the name of the performer respondent number 3 is struck off at the risk of the applicant. Now service is complete.
Lord.
What is this IA for?
IA for Lordship, there is a delay of 48 days.
Where the other side is appearing?
Lordship, notice some name has been shown.
Name has been shown. Okay. This court have next. This court have also taken note of that this is an application under Section 5 of the Limitation Act for condoning the delay of
48 days.
48 days. Condoning the delay of 48 days in preparing the accompanying second appeal against the judgment and decree dated 7/6/2019. Huh?
Lordship.
Where is that order? Against the judgment and decree dated
Lordship, page
7/6/2019, passed in title appeal number 21 of 2014. Taking into account the reasons assigned in the instant application, which in the opinion of this court constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act, the delay of 48 days in preparing the accompanying appeal stands condoned. The registry, accordingly, the instant application stands allowed. The registry shall register the accompanying appeal. This court further directs the applicant to file a fresh memo of parties in view of the striking out of the performer respondent number 3 in the instant order in the memo of appeal before the registry, and the registry shall on the basis thereof make necessary changes in the cause title of the regular civil appeal, as well as also update the same in the CIS.
Lordship.
The same shall be done within 3 days from today.
Lordship, a copy may be given. Lordship. Lordship.
You don't have a right to get a copy.
Item 25.
Yes, why the matter has come?
Lord, as per office note dated
Granted appeal on
19/3/24, your Lordship. As chair of title suit has been
The record reveals that the LCR of title suit number 1/2019 has not yet been received. So, taking into account the above, the registry shall take appropriate steps for requisitioning the LCR of title suit number 1/2019 at the earliest. So, list the matter for hearing immediately on receipt of the LCR.
But May I please, the Lordship?
Mm.
My lord, in this matter, as per office note dated 13/3/2024, service upon respondent number 3 to 7 are awaited, Lord.
My lord, well, during the hearing of the my lord, injunction petition, my lord, 3 to 7 did not took part. And my submission is not there are no necessary parties here, my lord.
Huh?
But they have not taken part in the hearing, my lord.
Very well.
And also they have admitted at page number 102, my lord, in their pleading. They have no claim against them.
This is against what? Injunction order.
A injunction was rejected, my lord. Against that, they have filed an appeal. They were the plaintiff. They have a simultaneous claim of, my lord, title and adverse possession of the plot of land. And they're enjoying a stay, my lord, in the appeal, my lord.
Where? Here?
Yes, my lord.
How?
That was, my lord, we filed a review earlier, but review was again withdrawn.
Parties are directed to maintain status quo in respect to the Schedule B land till the disposal of the appeal. It is made clear that the nature and character shall not be changed during the pendency. That's not. And that injunction was refused.
Injunction was refused in the lower court, my lord. Before the lower court.
Yes, what is your case?
Lord, actually, I am not. This matter may be taken up after Supreme Lordship. My senior Mr. D.P. Bora is on lake, Lord.
Who is on lake?
Mr. D.P. Bora, Lord.
Where is he?
On lake in court number 24, Lord.
What is the suit for? Where is the plane?
94, my lord. Page 94.
You are in possession.
No, my lord. That particular plot is filled, my lord. Nobody is enjoying that.
No, this is under our position, my lord. It will be.
Anyway, you are not in possession.
No, the status quo order has been granted.
Anyway, that is a different thing. You are not in possession.
No, my
What is your claim? On the basis of adverse
No,
possession?
Yes, my lord.
Yes, my lord. Prior to the taking over possession by the other side, my lord, we were in possession, my lord.
You were in possession till when?
Till
Show
my
me,
lord,
show me your plane.
till filing of the title suit, my lord.
So, where is your plane?
At page 94, my lord.
Makhani Borua.
Yes.
Tormila Borua. Makhani Borua alive?
Yes, my lord. Page 9, para 9, page 99, my lord.
What is your document to show that you were at all in possession at any point of time?
My lord, all along, I was in possession. There are a person, my lord, who are my tenants, my lord. Till 36, 2023, my lord.
Mr. Bora, I am dismissing your appeal. No ground.
My lord, kindly,
Absolutely no ground.
my lord, kindly not today. Today I am suffering from severe back pain, my lord. At least,
Okay, we vacate the order.
no, my lord. At least
No,
some other day-
absolutely, this can't be. This is encourages. How can these orders be passed? You have nothing. First of all, Mr. Bora, kindly appreciate one very important aspect.
Yes,
You are claiming adverse possession.
Yes.
Okay? Your entire case is on the adverse possession,
Yes,
nothing more than that. And what is the requirement of adverse possession? You know who is the owner?
Yes.
Who is the owner?
my lord, the father of the
Father. Have you made a single statement that the father asked you to vacate and he have not vacated? Have you made any statement to that effect? And more particularly, adverse possession, to give a decree for adverse possession, it has to be a continuous one.
Yes.
You admit in your own case that you have been evicted.
evicted only on 36,
Whatever
2023.
may be, you have been evicted.
36, 2023, after a long period, my lord.
Understood.
Yes, sir.
But is it adverse to the true owner? Where is your statement to the in your plane? Show me.
Page 9, my lord.
Yes. No. Here where we mentioned.
My lord, para 4, my lord.
Para
Page-
16, page 101. Purchase the property in so and so in the name of the defendant number 1 and the father of the defendant who appears to be the true owners in the record, but they never came to recover the Schedule B land. As such, the right title and whatever got on the strength of the sale deed became adverse in favor of Parmananda Porua due to continuous possession with effect from Iman, and the possession become adverse in favor of Iman and from here for another 12 years without interruption. As such, the title of so and so became adverse and so and so. Can this be the ground? Can this be the pleadings for adverse possession? How long? You may stay for 100 years. 100 years also, you don't have a right of adverse possession.
My lord, next week, complete next week, my
My
lord.
lord, another point, my lord. They have in multiple pleadings, my lord, they have stated this is Benami, the whole transaction was Benami. As per section 4, my lord, the suit is barred of the Benami Provision Act, my lord.
Your lordship,
The suit is in fact not
part
maintainable,
hard-
my lord.
yeah.
And
I don't require to part. This matter will come to me on 27th. This is the matter on
My lord,
27.
Not
No,
twenty-seven
no,
and
my lord.
28, my lord, on second, my lord, on first or second.
I am vacating order.
No, my lord, on
Order
27
will
and
vacate it,
20
my lord.
Okay, okay. We'll have it on 28.
on
First,
27
this is
and
the
20.
matter on 1st of
My lord.
April 2024. Full stop. This court, in the facts, after hearing the parties, is not inclined to extend the interim order passed on
31/7.
on
31/7/23, my lord.
31/7/2023.
Always.
Not inclined to extend the interim. Yes, what is this? Oh, none appears. None has appeared on behalf of the petitioner on call. It is also seen that in spite of the direction passed by this court on 29/11/2023 to take press steps, no steps have been taken, as is reflected in the office order dated 11/1/2024. Under such circumstances, this the matter again on 1/4/2024. It is made clear, no, this court, in the facts of the instant case, is not inclined to extend the interim order. You are not there in the transfer petition. Will you want?
No, lord.
T. Sharma? This matter name Ranju Talukdar? No. You are C. Sharma? You sure? Ranju Talukdar was a transfer petition, you are not there?
Let me take a look.
Chinmoy Sharma. Okay, you are not. You are Chinmoy Sharma. Huh? Your name is there? Transfer Ranju Talukdar versus Niranjan Oza. US Borgohai, Chinmoy Sharma, and something.
No, Lord, please.
Not you. Yes, what are these IS for?
Lordship, this IA is for restoration of an IA, Lordship.
Restoration of an IA.
Lordship, the main RSA was dismissed for default.
How many people have again died?
Again,
Again, 4A has died. 4F has died.
Lordship, in this case, I made a mention for listing, Lordship, 2001 RSA, Lordship. It was dismissed in the year 2013, then 2019, one IA was filed for restoration. That was also dismissed after the court on its own issue notice, Lordship. Thereafter, none appears for the petitioners, then that was dismissed, Lordship. Then again, they have filed an IA.
No, this IA business has to stop. No further, no substitution. You are paying for whom, madam?
And for 4B to 4E and 4G, 4H.
4B to 4G and 4H.
Yes, but I am for 1 and
4B to 4H.
I will appear
4B
for
to
the
4B to 4G.
Lordship.
But 4F has died.
4F Lordship died. I have already informed. There is a direction on 22
When did he
9.
die?
Lordship, he died on 29/4/2018. And there is a direction for in this code 22/9/2023 to file substitution. They took time to file substitution. Thereafter, they have not filed.
This is for restoration.
But at that point of time,
Appeal of 2001.
And
Is there a stay?
Yes, Lord. No, there is no
Okay.
stay, Lordship. The execution has not been proceeded.
Oh,
And
execution, let
one
the execution
CRP is
proceed.
also, CRP is also pending, Lordship. That I have also mentioned, Lordship.
There is a
Item
come-
52. Against the execution court's order, Lord. Executing court passed an order that was a challenge in CRP, and there is also one condemnation application.
And it was dismissed for
default.
Earlier IA was 4126, Lord.
uh, 2012.
Yes.
Interim orders have been vacated. Then once in 2012, 2012 restored. Again, it has been dismissed. 2013.
Yes, Lord. Against that 4126, Lord. 4126, your
What is
Lordship.
item 52?
And 4126, your Lordship will find from the very first date court on its own issued notice, Lordship. On that day also none appears for the petitioner.
In this matter, I would like to submit that the advocate was dealing with it.
Who was appearing on the last occasion?
Last occasion I appeared.
Who is Mr. G. Sharma?
That is wrongly typed.
What is this IA for?
On donation of filial.
And what is this CRP for?
CRP for lordship against the order passed in the execution.
What?
Execution proceeding.
Section 47 petition, they filed Lordship judgment letter that was rejected by the executing court on 4/5/2022. That was challenged, Lord, under 115.
So what is wrong with this order?
I'm not
There was a
clear.
direction passed by this court. Execution is stayed because of this.
Lord, there is no stay, but Lordship execution is.
And some people have died.
Yes, Lordship.
And for that they have filed an IA.
No, substitution was not done, Lordship.
So what is this? Why there is no order in this CRP?
In condonation.
Why the
notice,
CRP has not been registered?
Lordship, as because there is a condonation application, 115 application.
But there is no stay.
No, Lordship.
Then?
Execution not proceeding, Lord. Because of pendency of these cases, Lord. In CRP,
And in
there's a-
this thing, our authority is going to present submitted the connected revision application is going to an order has been passed and has been still accompanied. What is the ground? What is the delay? How much?
11 days. It's CRP lordship.
CRP is 11 days.
Yes.
Yeah, the problem arises. No? Why there is a delay of 11 days? There is no mention.
Uh, Paragraph number 4.
What does it say? It says that you have received the certified copy on 26, 2022. You had the time till 5/49/48. You could have filed from the date of the order. And then application was made on 15/6 and you got it on 26, 5 days. So you could have done it till 13/8. Why did you file it late? Where is the reason? There is not a single reason whisper out here. Not
I'm
the-
not ready
Huh?
to argue with example something. I'm not prepared.
And madam, is the case severable? This judgment which has been passed, can it be severed?
Decree, Lordship, decree is very, the revenue authorities are directed to demarcate the lands. And after that, if dependent number 4 has any share, Lordship, and then the
But
share,
isn't the dependent number 4's estate is represented?
Lordship, in execution, they can implement themselves,
No. Has the defendant number 4's estate,
Lordship,
who is the respondent number 4 here,
Lordship.
is represented by somebody?
I am representing 4A, 4,
Who are those? 4A and 4AF, who are
the
those?
legal heirs of the original defendant number 4, Lordship.
So therefore, the defendant number 4's estate is duly represented.
Lordship, only one is waiting for substitution.
Unless why should we delay unless these matters out there as to whether the restoration can be done or not?
2001 matter, Lordship.
That is why
Lordship.
matter requires to be restored, otherwise dismiss, whatever it may be. But if we don't do anything to that effect, unnecessarily this restoration business, if the defendant's estate is duly represented by somebody, so why not? What is the problem? One has to be more practical in this aspect. You can't keep the matter delayed because this is not only, you see, this 11 days delay is hampering you more than a 1,000-day delay. So if file a delay application with all the dead people out there, it's very easy.
I am ready to appear for the legal heirs, Lordship. Other legal heirs.
Not necessary whether you appear or not. We dismiss that condonation application, the matter goes 11 days or what. There's not a single word of whisper out there. So we dismiss it. So the appearance of the, I'm not passing an order against the dead people. Matter allowed. So you can go ahead with the execution. This is the only way out. Because one has to be, you can't have it in the time as if similar to 1908. What? 2 weeks. This is matter is coming up on 27. Not 2 weeks. The record reveals that that in spite of due information, the petitioner, the applicant have not taken steps for substitution of the legal representatives of some of the legal representatives. This court have also taken note of the application filed for condonation of delay in CRP number so and so. In being IA number so and so. It was CRP IA.
2699/2022.
Wherein, although there is a delay of only 11 days, but there is no reasons, not a single whisper about the reasons. Under such circumstances, this court is, however, not convinced with the said application, the delay, explanation of the delay. Be that as it may, Mr. Sri Sharma appearing on behalf of the applicant submits that he requires some time for which for the end of justice, the matter stands adjourned to be listed again on 1st of April 2020. Itu ni ya.
2852.
29. Yes, Mr. Ghosh.
My lord, in case I may be allowed to take fresh steps on respondent number 2. Because HSC has
Respondent number 2.
changed
The
the
SK Ghosh, the learned counsel appearing on behalf of the applicant submits that in view of the office note dated 19/3/2024, he would like to take fresh steps upon the respondent number 2. Accordingly, the applicant is directed to take steps by way of registered as well as usual within 7 days from today. This is the matter after completion of service.
Wait, wait. 30 and 31 is a connected matter between the same parties. 30 and 31 between the same parties is a connected matter. Their service upon the respondent number 2 otherwise complete the scheme and one
What is the IA for?
IA for IA 1592.
What is that?
Okay, there in this case, what is the respondent number 1, who happens to be the sister of the father of the applicant, filed a testamentary suit before the trial court lordship for granting of a will allegedly executed by the father of the applicant in favor of the respondent number 1. Lordship. The state suit, the one near relative had contested the suit, and thereafter the state testamentary case converted into probate title suit. Lordship. And petitioner, although where applicant were made parties in.
Oh, you did not know.
Yes, sir.
You were, that matter.
Yes.
What will happen this way or that way?
Yes.
You are paying for the respondent.
Yes, one.
Delay condonation.
Yes.
901 day.
1 day.
He didn't know.
Yes.
You file objection.
Substituted service effected.
Huh?
Substituted service was there. Paper
On you.
publications. Yes. Page 14 of the indication. This is the order of the trial.
Page 14 of
the application, the IO 1590.
copy are represented report of publication of under 520 respondent number 1 and 2 received. Petitioner number 1 prays for keeping a copy of the publication with the CR. Where does the respondent number 1 and 2, who you are paying for whom?
And for the applicant.
Understood. 520 is against whom? Substituted service against whom?
Against the present petitioners.
So
They
that
were-
was done on 31/7/2014.
Yes.
Okay. Now the present petitioner resided where?
As per the statement,
Mumbai.
one is Mumbai, another is
petitioner-
Canada.
Huh?
Two applicants are there. One is residing in Mumbai, another is Canada. They were the daughters of the predecessor in interest of the respondent number 1. So, after divorce with their mother, they abandoned their father and they resided at Mumbai, and then one of them left India.
No, did you
And
affect,
during this time,
did you affect substituted
Yes,
service
yes.
by paper publication in Mumbai?
yes, yes, my lord.
Show me. Where is that notice? Where is the paper publication? Paper publication is where?
The paper publication as per the
Yes.
order,
This order says that
Where? Where was the
Can-
paper publication?
kindly come page 23. Here in this case, the petitioner applied for the copy for the paper, but it was missing in the record. I have a categorical statement in the IA.
Newspaper so and so. Paper according to the newspaper Telegraph published on Iman, wherein the
Page 24.
now newspaper this Telegraph
Yes.
is which edition? Mumbai edition.
Yes, of course.
Show me that.
I don't have filed any records. My lord.
Well,
I have to. But this is on the record, my lord. This is on the record. The order says.
well, there is no paper in publication. Telegraph, whether it was published there, and where is the order passed? Pursuant thereto.
Pursuant thereto, Lordship, expertly order dated 31/7/2014 as page 14, Lord.
14.
Yes.
How did you know?
If they came to know in the year 2021 from the maternal uncle of the applicants that the probate was granted in favor of the respondent number 1. Thereafter, they made an inquiry in the court. Thereafter, found that the probate was granted in favor of the 1, and another suit is pending, which is also the subject matter of the suit is also
Mr. Olaskar, have you filed any objection?
not mine.
Are you filing?
My lord, the
Don't you think
testamentary
that this is a case for fit for with condoning the delay?
the testamentary appeal itself may not be maintainable. Because basically they are challenging this orders at page 14 and
No, therefore,
the direction for going ex parte against that. Basically, they are challenging this. Your lordship will be examining the validity of this order. And under section 299 of the Succession Act, this cannot be done.
no,
This-
you see, if we don't go ahead with this,
Right.
we can't go ahead with the suit.
My lord.
That suit also can't be gone ahead.
My lord, they should have initiated proceeding under Order 9 Rule 30.
Huh?
Order 9 Rule 30.
Order 9 rule,
13, my
Ah. Who?
for setting aside ex parte.
They?
Yes, my. That is the appropriate way. Because this.
No, that I can do. First I have to condone the delay, then I have to register this thing, and then I have to say that let him go. That is the only way out.
But
If I
the
don't do
condonation of
that,
delay will affect the
Huh?
appeal. Condonation of delay, the same ground is taken in the appeal, I suppose. Assuming the same ground that is taken for condonation of delay would be taken in the appeal. So if delay is condoned, then they automatically succeed in the appeal, and appeal is not maintainable in this current form.
if I have to say the appeal is not maintainable, then also I have to say, condone the delay. Can I say that without condoning the delay? Tell me. Huh? As of now, this appeal is not registered also. If it is registered also, I can say something. It can't be registered. I can't pass an order in the appeal.
So your lordship can condone delay, providing
Without
that
prejudice.
yes, without prejudice.
We condone the delay
Without prejudice to
on the grounds stated, however, without prejudice to
the appeal.
the objections which the respondent may have in the testamentary.
My lord.
I think that is the best way.
Yes, in relation to this ground.
This is an application file under section 5 of the Limitation Act for condoning the delay of 901 days in preparing the appeal. against the judgment and order passed by the learned district judge Karimganj in probate title suit number 65/2014 arising out of missed testamentary case number 15/2014. Pustak. The grounds which have been mentioned in the instant application is that the applicants that the applicant number 1 resides at Mumbai and the applicant number 2 presently resides at Canada, Montreal, Canada. The applicants did not have any notice about the said probate title suit number 65/2014, and only at a very late stage, only on, when did you come to know? 1/10/2021 came to learn about the granting of probate in favor of the opposite party number 1 from the maternal uncle of the applicants. Immediately thereupon, steps were being taken and the appeal was filed on 19/5/2022. Yes, Mr. Counsel, how do you explain? Earlier it's okay. From 1/10/2021 till this 19/5/2022, how do you explain? There's no explanation.
1/10/2021, Lordship, they came to know and thereafter they asked for an advocate to verify in the court. Thereafter, the copies was obtained 2/11/2021. Thereafter, they met an advocate in Guwahati.
No, you got the copies on 8/11/2021.
Yes, sir.
Then why did you take another 6 months from there?
Lordship, since they deciding outside, Lordship, they engaged another advocate who came to the present council, Lordship.
No, then also you knew. Then also the appeal is 3 months. How do you explain this?
After some documents was missing, and again the present engaged council asked the petitioner applicant to obtain the same from the Karimganj, and during this process some delay occurred. And I have explained the same on paragraph number 4, 5, and 6.
I've seen it. Not satisfactory. Not satisfactory. Okay, with the cost. Steps were being taken as stated in paragraph number 7 of the said application. And in that process, the appeal was only filed on 19/5/2022, which had occasioned a delay of 901 days. This court have also taken note of the order passed by the Supreme Court on 10/1/2022, whereby the period of limitation was enlarged up till 28/2/2022. Taking into account this court have also heard Mr. O. Laskor, the learned counsel appearing on behalf of the opposite party, who submitted that as to whether the petitioner have not received the notice which was published in terms with Order 5 Rule 20, whether the applicants have not received about the notice which was published on in terms with Order 5 Rule 20 can only be seen from the advertisement which was made. We further submitted that this is the fifth case where the applicant ought to have approached the learned court of the district judge, Karimganj, rather than filing the instant appeal. He submitted that he has no objection in condoning the delay, but however, while doing so, the grounds on which the condoning of the delay should not prejudice the defense of the opposite party in the connected testamentary appeal. This court, having given a due consideration to the matter, is of the opinion that there is a valuable right and from a materials on record, it prima facie appears that the applicant only came to learn on 10/1/10/2021. But however, to know the said aspect of the matter and as to how the process was duly effected, how the summons were duly effected, it would be required to peruse the materials on record in the probate title suit number 65/2014, which however this court cannot do unless the testamentary appeal, connected testamentary appeal, accompanying testamentary appeal is taken on board by this court. Accordingly, this court condones the delay of 901 days in preparing the accompanying appeal. But however, this condonation of delay shall not prejudice the defense of the opposite parties who are the respondents in the accompanying appeal. With the above, the instant IA stands disposed, the registry shall list the accompanying appeal, register the accompanying appeal, and list the matter in the first week of April.
It may be
On 5th of April.
copy. Copy may be furnished.
Hmm?
Copy of the appeal may be.
Today.
Okay.
Economy di দিব at least this matter economy লগত ইয়াৰ লগত the IO number so and so the instant CIP IO be listed along with the on 5th of April.
The interim order pass earlier.
The interim order passed earlier shall continue till. Yes, what is it?
Preparing a matrimonial appeal, but I had a delay of 12 days.
12 days.
Lordship, to the veracity of the statement made in paragraph 2, because the order is not annexed, so I cannot state whether the statement with for certified copy application, because order is not annexed along with this IA lordship. Because the petitioner might have been aware, because on 12/1/2023.
This is an application filed under Section 5 of the Limitation Act, taking condonation of 12 days, delay of 12 days in preparing the accompanying appeal against the judgment and order dated 12/1/2023 passed by the Learned Court of the District Judge Jorhat in title suit bracket M case number 46/2019. This court have heard the learned counsel for the parties and have also perused the grounds mentioned therein. From the above, this uh, from a perusal of the said application, this court is of the opinion that the same constitutes a sufficient cause for condoning the delay of 12 days. Accordingly, the delay stands condoned. Full stop. The registry shall register the accompanying appeal and list the matter for admission in the second week of April. Full stop. IA stands accordingly.
Lordship, a copy of the
Copy.
memo of the appeal may be served up.
I'll serve.
Deeply obliged.
Much.
May I please report? So in this matter, the respondents have filed their affidavit yesterday. We pray for sometimes find out like
What appeal? Appeal.
for the appeal, my lord.
For what?
Against the learned trial court has rejected our prayer for injunction, my lord.
Then?
Against that order, we have preferred this appeal, my lord, for the case. And your lordship has already passed an interim order in regard to the alienation of the social property.
Ah.
So they
Then?
have filed their affidavit yesterday, my lord. The affidavit is not on record.
I am going to vacate it if you say anything more than that. Don't say anything more. When
Why
is the
not?
trial court's next date fixed?
28/5.
28.
The instant appeal, I'm disposing it of, continuing the stay order till the disposal of the IA, the injunction application by the trial court, and nothing more. And I will ask the trial court to dispose of the said injunction application as expeditiously as possible within 30 days from the date of 28/5.
My lord, my simple submission is here. They are surfacing the material fact in this case, my lord. They have asked the injunction here also, along with the appeal. They have surfaced material fact. They have got their share, my lord, and sell out. And they take the injunction on our land, my lord. I have filed the affidavit yesterday, not listed here, but I have a copy.
I've seen it.
I have a copy, my lord.
I have a copy.
My lord, you are very much clear, my lord. I have annexed the sale deed.
We
and-
do one thing, direct the learned trial court to take it up on 8th of April. And direct the trial court to dispose of the injunction application within that.
Yes.
Within 1 month from that. I think that is a better option. Because you see, there should not be two parallel proceeding, one injunction proceeding going
Yes, my
there
lord.
and here.
No,
So
they are not
if I
servicing the
say
public.
anything out here on merits, that proceeding becomes useless.
Yes.
So let this order which I have given a very limited stay, not to alienate, nothing more than that.
Yes, my lord.
So that alienation, you can use whatever mean. If you are in possession, you use it. There's nothing, not to alienate till then. Good. I make it very clear. The instant appeal is directed against the order dated 25/1/2024 passed by the Court of the Civil Judge Senior Division number 4, Kamrup Metro at Guwahati. There are 4 nowadays.
No, my lord. That is a 3, my lord.
Division number
3.
3. 3 होगा लगे थे. But the number 3, Kamrup Metro at Guwahati. Whereby the learned trial court did not grant an ex parte ad interim injunction and rather issued notice. It has been brought to the attention of this court that in the said suit, parties have duly appeared Have you filed your objection there?
Yes, my lord. Objection.
No,
is
no, no,
I-
there.
No, my lord, I have received shortly. I am going to file.
Will you be able to file it by 8?
Yes, my lord.
Okay. It has also been mentioned by the the learned counsels for both the parties who are present before this court, that the learned trial court had fixed the said injunction proceedings along with the suit on 28/5/2024. This court is of the opinion, this court by an order dated 7/3/2024 had granted a limited injunction to the plaintiff to the effect that the defendants shall not alienate the suit property. It was also made clear by this court that the said injunction order is only limited to alienation by the defendant and nothing further. Next. This court further finds it very relevant to take note of that the injunction proceedings are pending before the trial court and all the parties are duly represented. Under such circumstances, to continue a parallel proceedings before this court would not be in the interest of justice. Accordingly, this court is also mindful of the fact that an injunction order is operating against the respondents herein, who are the defendants, in view of the order passed by this court on 7/3/2024. Accordingly, though the learned trial court had fixed the injunction proceedings on 28/5/2024, this court directs the learned trial court to prepone the said injunction proceedings, being Miss case number
70 of the 2000.
Miss case number 70/2024 to 8/4/2024. Full stop. The injunction order which was passed by this court on 7/3/2024 shall continue till the disposal of the said injunction proceedings, being Miss J case number 70/2024. Full stop. This court requests the learned trial court to dispose of the said injunction proceedings at the earliest and preferably within 30 days. With the above, the instant appeal stands disposed. Full stop. The party, full stop. Above here, I can dispose of you. The parties who are duly represented before this court are directed to appear before the learned trial court on 8/4/2024 and produce a certified copy of the instant order. The defendants who are the respondents herein would be at liberty to file their objections on or before 8/4/2024. I extend.
Petition.
Mm.
To substitute the legal as of resolution number 2. So this, that has been mentioned, kindly see page 7, para 2.
Appeal and died.
Respondent.
Huh?
Respondent number 2. Respondent number 2 died.
Respondent number 2 died.
Yes. And it came to our knowledge on 8/1/24 and we have filed this IA for substitution on 11/1/24.
Only one IA? When did you file this?
11/1/24.
This is an application under Order 22, Rule 4 of the Code of Civil Procedure for the purpose for substitution of the legal representatives of the respondent number 2 in view of the fact that the respondent number 2 expired on 9/10/2023. This court have also duly taken note of that the applicant was informed about the death of the respondent number 2 on 8/1/2024 and immediately on 12/1/2024 the said application was filed. This court also having perused in that view of the matter, as the right to sue survives upon the respondent, upon the legal representatives of the respondent number 2, this court substitutes
There's 8 men. Their names are wife, daughter, and son. 3 people. There's 8.
Substitutes the opposite party numbers 21, 22, and 2 Roman 3. Page 5 against the name of the respondent number 2 in the accompanying appeal. The applicant who is the appellant is directed to file a fresh memo of parties before the registry of this court within 3 days from today. And on the basis of the said memo of parties, amended memo of parties, along with the and the order passed herein, the registry shall make necessary changes in the cause title of the memo of appeal, and also the update the same in the CIS. IS stands disclosed.
Only make it 5 days. 3 days are only holidays. Saturday, Sunday, and Monday. 3 days are holidays. So can you make it 5 days?
Well, on a within 28/5, 28. 3 days to year. Are you appearing for 21223?
Yes, sir.
You are appearing.
Yes.
So you are what's your name?
P. Hazarika. P. Hazarika.
Ms. P. Hazarika appears on behalf of the newly implemented respondent number 2122 and 23, along with the other respondents.
Yes, sir.
List the matter for hearing. List the appeal for hearing in due course.
51.
Yes, what is this?
Actually, this is a application. CRP is against the dismissal of a limitation petition before the trial. CRP is against the dismissal of a limitation petition before the trial court because he had approached the court.
Before a trial court.
He had approached the tribunal belatedly, therefore it was dismissed. And against that, he is here. Now that the insurance company happens to be a company in Bhutan.
Oh.
Therefore, I am in.
Oh.
Now, Lordship, by the last order, I was directed to serve the company through the MEA. So, Lordship, my instruction telephonically is, Lordship, we can give it to the embassy of Bhutan. But the insurance company, Lordship.
Where have you filed this case?
Lordship, an accident occurred in the district of Barpeta, Lordship, and the MSCT case has been filed before the district court, Lordship, at Kamruk Metro in the year 2013. And 2014, Lordship, the insurance company came and filed its WS. And in this WS, this record stated that this policy is valid and within Assam, that geographical area is covered under this policy. thereafter, Lordship, that case was proceeded for SRWS. And ultimately, Lordship, that case was filed on due to non-appearance of the advocate, Lordship. And when it came to knowledge, then the present petitioner was filed an application for proceed the case. But on that day, Lordship, the court was directed to file another petition as because there is a delay. So for my knowledge, Lordship, that case was filed on. So there is limitation act is not applicable.
Where?
And before the trial court, Lord. So
Limitation won't apply.
not as
Why?
for as because Lordship, that case was filed on, Lordship. It's not dismissed.
It was
Filed on, Lordship. That filed on.
file on.
Yes.
What is that meaning?
It's Lordship. So for my knowledge, Lordship, it means for timing, it's details.
Show me, where is that order?
Lordship, kindly
Get to learn many things from you.
Lordship will see page 47.
Huh?
Lordship will come to page 47.
47. What type of order is that? No, we'll come to this, but before that, what is he mentioning? I don't understand.
Lordship, kindly come into page 24, Lordship.
Page
24, 24.
24. Yes.
The last order, Lordship. Claimant is absent without any step. Peruse the inter order. The case is filed till the appearance of the claimant, Lordship.
I'll. What is this file?
Lordship, I have seen, Lordship, another case, Lordship. That file on means, Lordship, that
Kept in abeyance
yes, Lordship, till the appearance
of the claimant.
Lordship. So that's why, Lordship, the limitation act is not applicable, Lordship. So
Because the matter is pending.
yes, Lordship. So, Lordship, when it came to knowledge, the present petitioner, Lordship, he was appeared and filed a petition for proceed the case, Lordship. But the trial court has suggested that you have to file another application as because there is a delay. So, Lordship, another delay petition has been filed, but that petition has been dismissed as because the delay has not been properly explained, Lordship.
Then?
So, Lordship, that's why, Lordship, approach before this honorable court, Lordship. Lordship,
Now what is happening? Service has not been
not
meted out.
completed, Lordship. Before this trial court, Lordship, since 2013 to 2017 or 19, service has not been completed. As because the respondents belong to foreign country, Lordship. So that's why, Lordship, before filing before this honorable court, that thing happens. Several times notice has been done, but no response, Lordship. That's why Union of India has been made a party to serve the notice, Lordship.
No, Mr. Chaudhary, what have you done?
Lordship, what we can do
You
is,
can
Lordship,
do it to give it to your embassy or to your, what do you say out here in Bhutan?
Lordship, I did.
In Bhutan, what do you say? Your embassy or high commission or
There's an
what?
embassy, Lordship. So there's an embassy. So
You
what
have to
we
give
can
it
do
to
is
your
we can
embassy
give it to the embassy. That is all what we can do.
Yes, nothing more than that. You
Yes.
can't do.
That may be clear, Lordship. We'll give it to the embassy. But to persons, Lordship, that will be to the private respondents and the insurance company in Bhutan. That will
No, how service is affected as per the CPC upon the foreign entity?
Lordship,
It is to the embassy.
so for my knowledge, Lordship, CPC is so far guideline is given CPC. If a person, Indian person living in the foreign country, then Lordship, Indian embassy will serve. But here, the person, their foreign country belongs to foreign country, Lordship.
You don't go into that complicated. We will do that. But how do you affect service on a person which is from the foreign country? Basically, there will be. If there is a cause of action arises, you can't say if something, just for example, some crime is being committed now, some civil AI is committed by some person out there. Are you going to say that the foreign national would not be liable? So you kindly see section 13, how affecting a service outside the country, how is it done? will be there in order 5. They kindly see order 5 rule 26. Order 5 rule 25, where the defendant resides out of India and has no agent in India empowered to accept service, the summons shall be addressed to the defendant at the place where he is residing and sent to him or by post or by courier as may be approved by the High Court, by fax message or by electronic email or by any other means as may be provided by the rules made by the High Court. And if there is a postal communication between such place and the place where the court is situated, provided where any such defendant resides in Bangladesh or Pakistan, the summons together with a copy thereof may be sent for service on the defendant to any court in that country, not being the High Court having the jurisdiction in where, provided that where any defendant is a public officer, so and so not belonging to Bangladesh or Pakistan Railway or a servant of railway company of so and so, then service whether in exercise of any foreign jurisdiction vested in the central government, a political agent has been appointed or a court has been established or continued with the so and so. So this will be done in terms with order 21 rule 26. Then why you are saying that it cannot be done?
That's why, Lordship, I have made a party to the Union of India to serve this.
You don't need to make him a party. The direction can very well be given by this court to that effect, directing the central government to effect the service. Don't make Mr. Architect or the come here this step. Isn't it? Has the notice been issued?
Already several times.
No, no, Mr. Architect, sorry.
Last order.
No,
Now, has the service been affected to Architect?
No.
Sorry, no.
no. We can only give it to the embassy.
This court, having taken note of the provisions of Order 21 or Order 5 Rule 26, is of the opinion that the service upon the respondent numbers 1, 2, and 3 can be effected. Either by post or to the embassy of India in Bhutan. Embassy of India in Bhutan.
They have got a consulate in Funchal, but Bhutan embassy is in Delhi.
Thimphu. Phuntsholing.
They have got a consulate in
To
Funchal.
the consulate of India in Phuntsholing, Bhutan. This is, I think, will be easier because it will be just bordering India.
Yes. Jairampur and
Accordingly, this court directs the petitioner to serve an extra copy of the instant petition to Mr. R.K. Dev Chaudhary, the learned counsel appearing on behalf of the respondent number 4, to effect service upon the respondent number 1 through the Consulate of India at Kunsuling, Bhutan. As regards the respondent number 2 and 3, the petitioner is directed to take sports service to Pitpost goes to Bhutan
Lordship, last time I have
through
taken,
overnight service.
but Lordship,
Over,
no reply has been come, Lordship.
through overnight service. They go. Or Blue Dart. Through Blue Dart. Through the courier services. So, this the matter again on 13th of May for further. The copy to Mr. Architect Chaudhary will serve during by 27, and the steps as directed above be taken by the petitioner by 27.
Highly offensive.
Yes, appearing. Okay. 1 and 2 has appeared. How many respondents are there? Okay. They have appeared.
Item. Yes, sir. My lord, the respondent here.
Yes, Mr. Biswas. You are for respondent number 1 and 2. Delay of 3 days.
3 days.
3 days.
I'm not sure, but if it is only 3 days, I have no objection.
This is what the registry finds out. I think
I don't have a copy of the other. The order sheet
that
is
copy
already not
nobody will have.
annexed also.
Yes, 3 days. This is an application under Section 5 of the Limitation Act for condoning the delay of 3 days in preparing in the revision application against the judge, against the.
It is an order, I think, 3923.
Civil division.
From what is
Against the order dated 38/2023, 39/2023, passed by the Court of the Civil Judge number 3, Kamrup Metro at Guwahati, in Ms. case number 932 of 2019, arising out of title suit number 209 of 2018. Hey, why is this limitation application filed? My goodness, what is wrong with these people? It's a 227 petition.
that is what because
We filed it, but the registry is directed
Leho.
to.
I don't have a copy of the.
So the order is passed under what? Order 9 Rule 4.
No, it is. I don't think so because it was dismissed for
Default.
default. So it would be order 9 rule 8. It would be.
No. You did not appeal. It was an order under order. Considering the amendments made in the order, I am of the opinion that no explanation, much less sufficient or satisfactory, have been offered by the petitioner for condonation of the huge delay in preparing the restoration application. There is no ground for condoning the delay and foregoing so and so. This is an application for condoning the delay in filing the petition for restoration, which was dismissed for default on so and so. I've heard the submission advanced by the learner appearing on behalf of the it's record. Application under order 9 rule 4 for restoration. That order. It is 12 to which order is that order 12 to 19?
Plus it. This order I have connect page 24 onwards, my lord.
I don't have a copy of those things.
That will be fine.
Where is that order of 12-2?
My lord,
Where is the order of 12-2? 2019, where is the
7-2 order is there, man.
plaintiff absent without stay, defendant number 2. Defendant not present. Court waited till 1 p.m. to tell dismiss on non-prosecution. However, counterclaim will proceed. Defendant to present. So if the plaintiff is absent, defendant is not present, is present. The plaintiff is absent, then you move under what provision? What was the suit fixed for?
My lord, this for the initial stage. My
Huh?
lord, only initial stage and
Before
there
going
is a
into the
counter
case
claim.
report,
Defendant also filed a counter claim.
where is the type copies of these orders?
My lord, I have annexed from my lord page 24 onwards, my lord. Page 20.
WS by the plaintiff.
My lord, they have filed a counter claim.
No. Before
Yes,
parting with
defendant
the
has
court
filed a
for
counter.
remand, enable remand. So,
He is the tenant of the defendant. You know.
Huh?
He is a tenant under the defendant.
no, you have filed a counterclaim
I have filed the counterclaim
against the
for
plaintiff,
seeking eviction
necessary order.
under some urban area.
No,
rental.
how could this order be passed on the 12th to 2019?
Yes.
The dismiss for default, it was not fixed for hearing. Was it fixed for hearing?
It was fixed for hearing, I think.
Then
I'm not aware. I don't have a copy of anything with me.
give him a copy.
My lord, delay petition we have served.
Mr. Counsel, give him a copy.
I'll supply.
Now, you don't need a copy. You have not been any way helping this. So 2 and 3 does not apply.
2 and 3 does not apply.
It is
8 would
fixed for filing of the written statement
in the counterclaim.
in the counterclaim.
Yeah.
The court may at best pass an order to that effect. But how can the suit be dismissed?
Because I think, I don't know, I've,
No, they kindly come to page 28,
yes.
page 27.
Please,
This is the early
27
order.
is the-
Parties are represented, seen petition filed, so and so, heard learned counsel, peruse the relevant provisions of the law as well as judicial precedent, to secure end of justice and deemed period to allow the prayer of the defendant petition for the last time with a cost of rupees 300
With the direction.
and with a direction to submit WS within 7 days without fail. Before parting it, it is mentioned that the provision is directed as it is a procedural learn meant for expediting and not for scuttling it. Further, so and so also enabled to exclusive discretion in the IMAR. Fix so and so for WS by the plaintiff.
But our WS was already on record. This is the
Actually, the WS for the plaintiff
plaintiff's WS.
when you file the counter. So therefore, the thing is, it was fixed for WS for the plaintiff. Next, you see the next date. Plaintiff absent without state, defendant number 1 and 2 are present, court waited 3 months, suit stands dismissed. However, counterclaim to have ex parte hearing. See this. So how can they have been dismissed for default? It was never fixed.
For hearing. However, the counterclaim will proceed. Fix such and such.
Has your WS been accepted in the counterclaim?
Yes, it has been accepted. It is fixed for issues, I think.
Then this needs to be restored. And where is the question of delay comes? 115.
68 days, it was filed before the.
Because for the restoration, they had called.
Yes.
Number no?
This has not yet been numbered. Filing number.
Is not.
Okay, it's the order impugned, the order challenged in the accompanying application is under Article 2 to 7 of the Constitution. Is an order passed whereby the suit was dismissed for default. Full stop. Taking into account that there is no limitation for in terms with Article 2 to 7 of the Constitution, full stop, the instant application is totally misconceived. Full stop. The registry shall register the accompanying revision application as a CRP IO and list the matter for motion on 28 on 28/3/2024. Okay, you don't need to be ready. I'm already ready. I stencil out. I will stencil close.
A copy may be served.
I'll serve.
Read the copy. Yes, you give that copy. You don't require any copy.
Problem.
Yes. 51 to 2 হয়ে গেল 51 হয়ে গেল None has appeared on behalf of the petitioner. It is also seen that no steps have been taken as is recorded in the office note dated 13/2/2024. List the matter again on 1/4/2024. It is made clear. No. What is this?
Lordship, I am most humbly Lordship. I am not dealing well with some viral type. So today,
That's okay.
not
Don't worry. What are you challenging?
The impugned order whereby the learned court below rejected my section 8 application by holding that
Section 8 application.
section 8 of arbitration complete.
And then, and therefore you are challenging here. We'll do it, we'll have it on some other day.
Yes,
Huh? Okay, let's have it on 3rd of April. Okay.
okay, Lord.
Let's-
Yes, Lord.
Uh,
Lordship, can it be on second, because from third to 8th, I will be out.
Okay, we'll have it on 29th of April. List the matter again on 29th of April. The interim order passed earlier shall continue.
Thank you.
Till the next day.
May it is your lordship, today the conducting council is having some difficulty, lordship. Can it be on 27th of this?
Service complete.
Respondent number 1 had appeared.
You have not taken steps upon respond number 2, 3, 4.
Their performer respond.
Then you have to go for striking off.
Their names may be struck. Their names may be struck off.
The learned counsel appearing on behalf of the petitioner submits that the names of the respondent number 2, 3, and 4 be struck off as they are performer defendants. The name of the respondent number 2, 3, and 4 are therefore struck off at the risk of the applicant, petitioner. The applicant, the petitioner shall file a fresh memo of parties before the registry of this court within 2 days, by 27/3/2024, and on the basis thereof, the registry shall update the cause title of the instant proceedings, as well as also the update and also in the CIS. List the matter again on 29th of April 2024. The interim order passed on 28/12/2022 stands extended till the next day.
Okay.
Transfer petition not as per office not lordship, a notice issued by registered post office refused to accept by the respondent. And lordship, the notice issued by a visual person that is issued by the father of the respondent.
You want the transfer from where to where?
From principal class Nalbari lordship.
Huh?
From principal class family court Nalbari lordship to the district session class Udal. The petitioner is staying in the Udal
Why?
with his parents. Her parents.
You don't have any, what is your source of income?
No, nothing. Only lordship.
You filed your written statement? Have you filed your written statement?
In that, no, Lord.
No.
No. That's it. It's all heard the minor side, Lord. Minor girl side, Lord.
I transfer for you. Well, you file your appear before the trial court at before the district judge at Nalbari. You want at Nalbari?
No, Udalguri. Lord.
Udalguri.
Yes.
At Udalguri on 13th of May and file your written statement. The district judge will also issue, as he has not appeared, issue notice to the plaintiff, the petitioner in the state, the respondent in the state proceeding.
Okay.
Go to 24. Yes.
But this care backup is taken cash flow method. And the put is created in Udalguri. This is around by the 75 kilometer from the Telugu to Udalguri.
How far is it?
According to Google Map, 75.4 kilometers.
So go there.
Because method he has no one to export hire. But from that method he has no income.
He'll pay you. He'll pay.
Honorable Court allow the petitioner, allowed petitioner, no objection.
Huh?
If honorable could allow this petition, I have no any objection.
You have no objection. Chalo, allow koi नहीं. You have filed your written statement?
We file,
Now, have you filed your written statement there
my lord, we file.
in Tezpur?
In Udalpur,
Udalguri, you have filed?
we file.
Hello. For appearance of both the parties out there on 13/5 in Tezpur. You wanted Tezpur?
Yes.
Allow.
Okay.
He has no objection. What is this?
Before your lordship, challenging an order where I'm being debarred from an expertise order of the lordship,
Which order? 122.
43 page number, and here I'm challenging the rejection order of page number 49, lord.
49.
49.
What application did you file?
Order 9, rule 7, lord.
49. What is the stage of the suit?
The state lordship at
Huh?
present. At present, it was state lordship.
Is the
That I
SBPH,
know.
SBPH, steps
SBPH.
before parliamentary hearing.
He has filed a written statement.
Yes, your lordship.
Then what is there?
Your lordship, may, may I please?
Yes.
Your lordship, this is the third application they have filed. And this is the third application where their expertise order has been, on the third, they have expertise order was not, it has been rejected. On earlier two occasions, your
No,
lordship.
no, Mr. Chaudhary, kindly appreciate one thing.
Yes.
In the suit, they have filed a written
Yes.
statement. No, appreciate.
Yes, your lordship.
In the suit, they have filed a written statement. Now
Yes.
tell me, what is the next stage of hearing? Next stage of hearing in a suit, what is the suit?
At the time of evidence, yes,
Evidence has not come.
but your lordship, see the conduct of the
No, understood. What
Your
is
lordship,
maybe as of now on
earlier
that?
on two occasions, their expertise has been
How
vacated.
can there be an ex parte?
Your Honor, earlier also.
No, no.
They have not filed WS, Your Honor, on both occasions.
Now, have
Your
they
Honor.
filed the WS or not?
On last occasion, Your Lordship. Your Honor, I have filed.
COVID lordship.
Your Lordship, kindly peruse my affidavit in opposition.
I find that.
I will satisfy the court.
No,
After
no,
that,
no.
Your Lordship-
I am not going to look into all these things. The matter is very simple. After the filing of the WS, you tell me when is the next date of hearing.
Your
Oh,
Lordship.
you answer me only that. That only simple answer. What is the next stage of hearing?
TW evidence is the date of hearing.
Now we are at the stage of SPPH.
Yes, sir.
Now tell me, how could the court pass an order on the order 9 rule 6 if it was not fixed for date of hearing? Tell me.
Your Lordship, the court has given enough opportunity on last two occasions, Your Lordship.
Understood, everything understood.
Your Lordship,
you see,
I want to
you
rely
see when
one-
it is passed.
Your Honor, I want to
When the
rely.
summons not
Your
passed,
Honor,
when
I-
the summons served but
Yes.
not in due time, that is the procedure when the defendant appears on the date of adjourned hearing and expired. So it has to be on the date of hearing only.
Your Lordship, the grounds shown in the petition, Your Lordship, kindly peruse. They have said that they have.
You want
They-
the matter to be your suit to progress.
Yes, I want to progress, but
in the state.
Your Lordship, that suit has been filed in the year 2018 yourself. On both two occasions, in spite of getting summons, they have, on earlier two occasions, they have not filed written statement, Your Lordship. On the last occasion, with the cost, they have filed written. In spite of the court order, they have been.
No, we
delaying the
will
tactics,
allow
Your
with the
Lordship.
cost.
No, Your Lord, till that no cost has been paid.
No, I am directing them for his area. Hello, we'll have it on, we'll hear more on that day. But the,
Yes.
Mr. Chaudhary, your case You don't have a case out
Yes.
there. He has a case, but he has
Your
to pay.
Lordship, I want to rely on that. Here is
Not-
Rajasthan
don't-
High Court judgments. Similar situation has
These simple, no, you basically answer, yes, I would have understood. The suit was at the stage of hearing, and as such, the evidence have happened, everything process, everything is complete, and then he wants to put the clock back.
Yes, Your Lordship.
Now tell me one thing, no, only simple question. Can he not participate at any point of time in the suit without
Earlier,
vacating?
earlier.
No, now also. Can you not? He can. Only this Order 9 Rule 7 application is for the purpose of putting the clock back. And that is the fundamental mistake the court has done, not understanding what is Order 9 Rule 7. Anyways, we want to delay the suit. Very well, we delay.
Your Honor, date may be fixed on 28th.
No, what is there? He's happy with the stay. Okay, let us have the stay till July. We have it in 15th of July. Okay. List the matter again on after hearing both the counsels, and here it will, this court is of the opinion that the matter would require further hearing, further lengthy hearing. As such, matter stands adjourned to be listed again on 6th of May. Interim order passed earlier shall continue till then. Simple 2-minute matter. Yes.
My lord, filing from WS, my lord.
WS?
My lord,
I have no objection.
No objection.
my last pair was next paper, page 18. 24, 4, 30.
You have not filed your WS.
My lord, my WS was ready and made a prayer to accept, but that was
Okay. Your WS is ready.
my WS was ready, but
Okay, we fix a date, you file your WS.
my lord.
I fix a date, you
Yes.
file your WS.
Yes, yes.
And what do? You are respondent.
I picked
Canara Bank.
my lord. In the Canara Bank is respondent.
You got a respondent matter.
I was dependent before the Lord.
No. Who are you?
Canara Bank originally claimed,
WS was accepted or no?
no, my lord. We made
Who-
a prayer.
No, who was supposed to submit the WS?
The petitioner, my lord.
Why? The petitioner is not Canara Bank.
In the money suit, my lord, Canara Bank
Plaintiff
is
is
the
the Canara Bank.
petitioner.
Oh,
My lord.
yeah.
In the, here he is the petitioner.
And how much is the amount you have to pay in the suit?
My lord, loan amount was 5 lakhs and the interest now 6,50,049.
Hmm?
Now it is enhanced up to 6,50,049.
Pay
So by
5,000.
the old person, my lord, his age is now 74 years. He is suffering from
Anyway,
India's
five-
treatment.
Five,
So, my
pay-
lord,
no, madam,
we
I will,
request
I will
the
allow
finance
you.
to
No,
reduce
I
the
will
interest.
allow you. Cost of 5,000.
Another 3,000 was there in the lower court also. Lower court also imposed it on the-
Where?
My lord.
When?
My
Earlier,
order-
earlier you paid 3,000.
No, my lord, my payer was, my lord, annexed 13, we have to pay, my lord, both the cost, my lord, but that was also rejected.
No, anyway, you pay 5,000 as a condition
Yes,
precedent for it.
yes, my lord.
This is an application filed challenging the order dated 24/4/2023, whereby the application filed by the petitioner, who was the defendant in the suit for accepting the WS, was rejected on the ground that the defendant did not file the WS within the time stipulated in terms with Order 8, Rule 1 of the Code of Civil Procedure. This court have duly taken note of that it was on account of difficulties beyond the control of the defendant which had resulted, or defendant oblique the petitioner, which had resulted for not filing the WS within the period stipulated time. Further to that, it has also been submitted by the Miss P. Devi, the learned counsel appearing on behalf of the petitioner, that the WS is ready and would be filed on such date as the court may fix. This court have also heard Mr. So-and-so, the learned counsel appearing on behalf of the respondent, who submits that he has no objection in if the WS is accepted, but however, a date may be fixed so that the WS can be filed in as much as the suit is otherwise getting delayed. So, taking into account the above, this court is of the opinion that the order dated 24/4/2023 is required to be interfered with. Then the order stated 23/11/2022 and 24/4/2023 passed by the learned trial court is required to be interfered with, and accordingly the said order stands set aside and quashed. The petitioner herein, who is the defendant in the suit, is directed to file the WS without fail on the next date so fixed herein on the next no, next line, please. Both the parties being duly represented before this court are directed to appear before the learned trial court on, where is it? Where is the trial court? On 18th of April. On 18th of April. 18th of April, there is no election, I suppose. No.
Oh, election.
Huh? No. No. On 18th of April 2024. Full stop. On the said date, the petitioner, who is the defendant in the suit, shall file the affidavit, file the written statement. Full stop. This court also have taken due note of that there are certain reasonable cost has to be also imposed. Accordingly, this court imposes a cost of ₹5,000 to be deposited by the plaintiff, by the defendant in the said suit, which shall be a condition precedent for acceptance of the WS. Thereupon, the trial court shall proceed with the suit in accordance with law. While the petition stands disposed, the interim order passed earlier stands vacant. Yes, what is this?
Well, the matter relates to the in a divorce suit, my lord, wife could not file the WS, my lord, because its matter was pending in the for mediation for 13 months. When it has come back, my lord, on that day I filed an application for WS and court has rejected it, my lord.
We do one thing, we have it on next week, because the other side is not there.
Yes.
With the liberty to mention.
Yes.
Okay. You mention the matter.
I'll-
Okay. List the matter again on 28/3/2024. Liberty is given to the petitioner to mention the matter for upgrading. Interim order passed earlier shall continue till then. Service not complete, madam. Can't help you. Service not being complete, the petitioner, the office note dated 23/2024 reveals that the service is not complete. So, let the matter be again listed on 10th of April 2024. So, the interim order passed earlier shall continue till then. In the meantime, the petitioner is further directed to take steps upon the respondent by way of Dusty routed through the registry of this court and file an affidavit of service on our behalf.
My lord, that is not possible because the petitioner is the mother-in-law of the. my lord,
Madam, you are not going to go. She is not going to go. You send your clerk. Clerk is going to go. I don't understand why the petitioner doesn't have to go. A clerk will go and give a report, and that too out here. He will go and take this, and then he will file an affidavit whether they receive or not. This is how you do, Dusty.
Because the matter was today even before the family court, you find a petition, they are also informing and this stay order also that yeah.
Understood, but do that. I think without affecting the service, this court can't proceed.
With regard to jurisdiction.
Hmm?
This petition is with regard to jurisdiction.
Understood. Serve it by justice with me.
But it
Yes, what is this?
Transfer petition,
Hmm.
wife taking transfer from Sonitpur to Bajai.
What about the service?
Service complete, my lord.
Till
Others has
date, no
already
ID
appeared.
card received. Notice was issued to the sole by registered post with 80 usual service any month. Till date, no ID card or concern affidavit affecting years also not received.
Others has already appeared, my lord. He filed affidavit also.
Who?
Mr. Ganguly appeared, my lord. Yes.
Okay, we'll have it next week on 3rd of April. List the matter again on 3rd of April 2024, taking into account that the respondent is duly represented. Post of interim order passed earlier shall continue till then.
All right.
This is regarding that the objection against the violation matter could not be filed. There was a order 39 rule 2 application, and in the meantime the record was transmitted to the appellate court. And immediately on receipt of the appellate court, the case was fixed for hearing. So the written objection could not be filed back. My lord, may kind of file my annexure at F1. page
Oh, that matter again. That matter is really the lot of litigation.
Yes, my lord. Anyways, my lord, we don't have any objection if they are allowed to file the written objection against our petition under order.
By filing a petition number in one, saying it on where in the suit.
Yes, in the order 39 rule 2A matter. They
You want to
filed-
file objection.
Yes,
And that was rejected.
that was not allowed actually.
Why?
Because the record in the meantime was transmitted to the appellate court. Appeal was pending. And immediately after receipt of the record, the court has fixed the case for hearing of that matter. And I filed the application that I may be allowed to file the objection. The court has rejected it.
Okay, okay. Now, we dispose it of.
Yes, yes.
This is an application under Article 227 of the Constitution challenging the order dated 5/1/2024 passed in Misday case number 572/2023 by the Court of the Civil Judge Senior Division number 1 Kamrup Metro at Guwahati. It is the case of the petitioner that an application under Order 39 Rule 2A of the Code of Civil Procedure 1908 was filed by the
Filed by the plaintiff.
plaintiff. And the petitioners herein, who are the respondents in the said application, wanted to file an objection to the said application, taking into account that the respondent taking into account that wanted to file an objection to the said application. It has been submitted by the Learned Counsel for the petitioner that on account of a challenge being made to the proceedings, the records were called for by the appellate court. On a challenge being made to the injunction proceedings, the records of the proceedings were called for before the first appellate court. The first appellate court thereupon, after disposal of the said appeal, returned the records. Under such circumstances, the respondent in the said application could not get an opportunity to file their reply. This court have also heard the Learned Counsel appearing on behalf of the respondent, respondent oblique the plaintiff, the respondent, appearing on behalf of the plaintiff oblique the respondent herein, who submits that he has no objection if the petitioners are permitted to file an objection. However, he submits that the petitioner cannot further delay the said filing of the said objection. So taking into account the above, this court, interferes with the order dated 5/8/1/2024 and directs and permits grants the liberty to the petitioner herein who are the respondents in Ms. case number 572/2023 to file their objection. The order dated 29/1/2024 passed by this court stands vacated and the parties are hereby directed to appear before the trial court. When is the next date?
Lordship, the next date is not fixed in this case because since the proceedings were stayed by the court.
No, trial court suit.
Yes, it was fixed today.
Today,
Next date is not given.
Next date will be given somewhere, it will be given.
Yes.
Okay, we can have it on 10th of April.
The next date we will file.
No, I can't give that. I have to fix a date for
Yes,
the
yes.
person. On 10th of April.
10th.
On 10th of April 2024. It stands vacated and the parties are directed herein to appear before the learned trial court on 10th of April 2024. On that date, the respondent, the petitioner herein who are the respondents in Ms. case number 572/2023 shall file their objections without fail. With the above observations and directions, the instant petition stands before.
Obliged.